Lordship had fixed the appeal hearing on 6th of May, my lord. I was led by Mr. Senior Counsel, Mr. Abhijit Mitra and Mr. Sarvapriya Mukherjee, my lord. We had forgot to take leave of your lordship to file the judge's paper book, my lord, in the department, my lord. I was humbly submitted.
You're out of time.
Yes, my lord.
The time কি করবো? Oh, Baba, to be mentioned tomorrow.
As your lordship pleases. Grateful.
Appellate side mentioning. Appellate side, item number 1. Sorry. Item number 2.
Well, I was addressing your lordship. My lord, this is that matter. If your lordship recollects,
Pass over, Mr. Bose. Nobody is there.
I am for the respondent.
Oh. So appellants have already made their submission.
Yes, they have. Mr. Abhijit Mitra was leading them. This is that matter where, my lord, the commercial court at Rajarhat has held that the suit is not a commercial dispute within the meaning of section 2C. We had filed an application for rejection of plaint.
Yes, sir.
For the appellants, my lord.
Very good.
My lord, it was our contention before the trial court that it is not a commercial dispute within the meaning of section 2C of the Commercial Courts Act. Now, before I take your lordship to 2C, my lord, kindly have a look at the plaint, which starts at page 18
Commercial Courts Act.
of the paper.
Acha.
So, my lord, this is an issue of subject jurisdiction. Now, in order for the commercial court to receive the action, it must first come to a conclusion that it in fact is a commercial dispute. Only then it can receive the action.
Yes.
Lord, page 18 of the paper book. Lord, your lordship will find page 18 onwards, there are total 41 defendants.
Yes.
And my lord, at paragraph, page 37, your lordship will find the reliefs claimed in the plaint is against the defendant number 1 to 32. They have reference to Form 5A of Appendix D, which is a mortgage suit. So they claim a decree for this amount as against the defendant number 1 to 32. And in default, they seek that the property according to them, which is mortgaged to them, should be sold. Now, my lord, kindly come to page 28 where the plaint starts. I just wish to draw your lordship's attention to a few paragraphs.
You were defendant number 41.
I am 41. It was my application. I have been, my lord, the coinage in the plaint is pro forma defendant. Because I have been impleaded, but there is no relief claimed against me. The case made out in the plaint is that there's a property 1 to 32, all are undivided owners of the property, co-sharers. 1 to 32 are also co-sharers. They apparently availed of a loan from the plaintiff and mortgaged their undivided share in the property with the plaintiff. Default, they could not repay. So the suit
Swandu. Yes.
So the suit claiming the amount in default, and they say that since there is a mortgage, they have a right to file a mortgage suit and ask for recovery of money and subsequently the prayer for sale of the mortgage property. Now, my lord, I will draw your lordship's attention to a few paragraphs in the plaint from which may I proceed?
Yes.
Yeah. So from which, my lord, I will substantiate that this does not qualify to be a commercial dispute. Now, my lord, the first your lordship will kindly take page 21, 28, page 28, paragraph 1 of the plaint. My lord, there is an unequivocal admission by the plaintiff at paragraph 1 that the defendant number 1 to 32 and the pro forma defendant 31 to 41 are the co-owners.
Yes.
Then, my lord, kindly come to paragraph 2. 1 to 32 were in need of funds for the purpose of their business and thus jointly approached the plaintiff to avail appropriate loan and financial facilities for a sum of rupees 7 crores and offered to secure the repayment thereof by creating a registered mortgage in favor of the plaintiff in respect of their respective shares in the said property. My lord, since we are at the demurrer stage, whether commercial dispute or not, but I am not going into the other aspect that whether there can be a mortgage of undivided share, to what extent, if there is no partition, to what extent, that may not be relevant at this stage. My lord, kindly now take paragraph 3. It was specifically agreed by and between the plaintiff and the defendant number 1 to 32 that the loan to be advanced by the plaintiff to the defendant number 1 to 32 would be utilized only for business purposes and that the said defendants would not use transfer the loan amount to any of their legal heirs or any representative. My lord, your lordship can make a note. There is no agreement of loan. There is no transaction of loan. There is no terms and conditions of loan. So these are bold assertions. Now, my lord, why I say this?
Yeah, which we'll take to be true at this stage.
No, my lord, I'll tell you, lordship, my lord, in case of subject jurisdiction, the court may look to the documents, the relief, apart from the averments made in the plaint, because had it been territorial, pecuniary, barred by law, whether the plaint discloses a cause of action, the rejection of plaint principles under Order 7/11, the court ought to have restricted its scrutiny only to the averments made in the plaint. My respectful submission of your lordship is, when the court is ascertaining subject jurisdiction, whether it can entertain an action, then, my lord, even the documents, relief, and whether it comes within the jurisdiction of the court, the subject jurisdiction of the court, but it can make a preliminary examination to ascertain whether it can receive the action, which can be beyond the averments made in the plaint. My lord, the strict principle, the age-old principle that one has to confine the examination to the averments made in the plaint, in my respectful submission, may not be applicable or is not applicable at the time when a special forum is receiving action under a special statute, like the Debt Recovery Tribunal, like the National Company Law Tribunal, like the Land Reforms Tribunal. These are forums which are specifically constituted to receive certain specific actions, not a general civil code where, my lord, Order 7/11 applications has to be ascertained based primarily on the averments made in the plaint. What the defendant says is irrelevant. Here, my lord, kindly see then at paragraph 4 and 5, they refer to two power of attorneys. Now, this power of attorney, if your lordship will see, they say that the defendant number in para 4 said defendant number 2 and 25 had authorized one of the defendant, which is defendant number 1, to execute, and similarly 26 to 32 has given another power of attorney to the defendant number 1 to represent them. Now, my lord, kindly come to para 6. based on the aforesaid representations of the defendant number 1 to 32 and relying upon the same and believing the same to be true, the plaintiff at the request and as per the instruction of the defendant number lent and advanced rupees 7 crore to the defendant number 1 to 32 by transferring diverse amount to each of the defendants. My lord, kindly pause here for a moment and my lord, kindly turn to page 40. Your lordship will find there is a second schedule which is mentioned in para 6. My lord, which shows that separate amounts have been given to separate defendants. So, my lord, 32 separate transactions. And no loan agreement with any of the 32 defendants. Then, my lord, kindly take para 7. In accordance with the agreement by and between the parties, there is none, my lord. There is none at least disclosed in the plaint or referred in the plaint. In furtherance thereof, the defendant number 1 to 32 acting to the defendant number 1 executed a deed of mortgage without possession dated 7 September 2016 in favor of the plaintiff in respect of such and such percent. Kindly, my lord, make a note of this, my lord. 78.07% in the property described in the first schedule. Unpartitioned, undivided share, deed of mortgage, security payment, the deed of mortgage, 7 September, records the terms and conditions of the defendant number 1. My lord, your lordship will find the mortgage deed starts at page 68. Well, I wish to draw your lordship's attention to some of the clauses in the mortgage deed. Your lordship will find neither in the plaint nor in the mortgage deed the plaintiff has ever mentioned that it carries on business or lending money is a business or it is something in usual course of its business. My lord, in order to come within the purview of the Commercial Courts Act, my lord, it is relevant and it is, my lord, mandatory for either a bank, a financer.
Commercial Courts Act.
দাও না, দুটো Commercial Courts Act দাও না।
এগুলো কি আজকে আসবে না ইয়ে?
Lord, may I hand over 2 copies?
We have it all here, Mr. Bose. That's the
My lord, neither the plaint nor the mortgage deed either mentions or states that the plaintiff in ordinary transaction or in its ordinary transaction has lent this amount of money. So if it is a solitary transaction and if you are neither a banker nor a non-banking financial company, so even if it is a loan, in my respectful submission, it would not qualify the test of 2C1, 21C Roman 1 of the definition of the Commercial
This
Courts Act.
property is used for what?
Now, I will come to that, my lord. Now, I will restrict myself to the averments and the documents in support of the
Do you
plaint.
know what this
Vacant
property
land.
is used for?
It's a vacant,
Vacant
land.
land.
Yes. It's a vacant land. My lord, it point was taken in the order 7/11. Now, my lord, if your lordship will kindly come to the mortgage deed. My lord, I had referred to paragraph 7. My lord, kindly come to the mortgage deed. My lord, 2 paragraphs from the mortgage deed. My lord, kindly take page 102, which is the schedule of the property, which forms a part of the mortgage deed. Page 102. Your lordship will find all that piece and parcel of land measuring such and such at Khatian number such and such, Dom belongs to portion of premises number such and such within such and such with structures thereon having total covered area of 400 square foot.
Yes.
So your lordship will see piece and parcel of land 394 decimals, quite a large substantial area of land. Your lordship will see at the end towards the covered area 400 square foot. Page 102. For the action of the election.
Yes. Yes.
So, my lord, the schedule at 102,
Yes.
then, my lord, effectively suggests that it's a vacant land. Now, my lord, one of the recitals of the mortgage deed would also suggest that it is in fact a vacant land, possession of his with a third party. Now, kindly take, my lord, page 90, the recital at the bottom of page 90. It's a part of the mortgage deed.
Yes.
And whereas the said mortgagors, co-owners, and other co-owners, except one co-owner, while being seized and possessed of their respective undivided share in the said property, entered into and executed a development agreement dated 20th of June 2013 with developer such and such. But however, the said developer could not develop the said property as per the terms and conditions of the said agreement, and consequently the mortgagors, co-owners, by their advocates letter of 17th of December 2015, cancelled and terminated the said development agreement, power of attorney and other purported documents, and consequentially none of the said development agreement or any purported document, supplementary document or power of attorney executed in favor of the said developer have any right, effect, enforceability as on the date, and the same deemed to have been revoked, annulled, cancelled, withdrawn, and redundant by non-operation and compliances of the parties therein, and or by act of parties and due to efflux of time. If any right exists, the same is deemed to have been relinquished, claimed, foregone, surrendered, and abandoned by the parties therein. Consequently, the mortgagors and owners thus has unfettered right and entitlements to develop and make appropriate construction on the said property by their own funds and capital.
Just because such a
Explanation.
section থেকে আসতে হবে I don't see কি করে আসছে Yes.
So development agreement in 2013 executed by all the co-owners. Cancelled by whom? By 1 to 32. So the other co-owners don't cancel. I am one of the co-owners. I don't cancel. They cancel. And they enter into this transaction which they say. So basically, your lordship can understand another developer has come in. So they want to develop this property. So my lord, there is a dispute inter se between the quotient. May not be relevant here at this stage. So our examination should be confined in my respectful submission.
Mr. Bose,
my lord.
we've heard you for some time now.
Yes.
A company,
Yes.
whether it carries on money lending business or not,
Yes.
has lent money to the defendants
Yes.
on their request
Yes.
for being utilized in business
Right.
against security
Right.
of undivided share in an immovable property.
Right.
Whether this amounts to a commercial transaction or not is the question.
Right.
You say it is not a commercial transaction because it will only be a commercial transaction if the plaintiff was in money lending business or in ordinary course of business. That was his business or one of the businesses.
My lord, if your lordship will hear, my lord, if your
Do
lordship.
we understand correctly?
Yes, yes, absolutely. Absolutely.
We are trying to understand.
Yes, yes, yes. Yes.
It takes some time to understand.
No, absolutely. So, my lord, now, my lord, they say it is commercial dispute on two grounds. First, they say that they come within the purview of, if your lordship takes the Act once, 21C, Roman 1, and they also say that they come within the purview of Roman 7, which is agreement relating to immovable property used exclusively for trade or commerce.
Right.
Now, my lord, first, if your lordship will kindly take Roman 1.
Yes. Has it been interpreted by any court?
Yes, several courts.
Show us.
Right.
Show us.
My lord, may I just interpret it in my way and then
Very
take
well.
your lordship to the judgment? My lord, if your lordship will see, the language of Roman 1 is very clear. It says commercial dispute means a dispute arising out of. So it must arise out of what, my lord? Ordinary transaction of merchants. So one class of persons mentioned in Roman 9 is merchants. So it has to be an ordinary transaction of that merchant. So if I'm a merchant and I'm selling grapes or I'm selling vegetables and I today give a loan for the purpose of construction of a building, that would not be ordinary transaction of that particular merchant. So it says ordinary transaction of merchants. Ordinary transaction is of great significance. So would then your dispute come within the commercial disputes? Otherwise, ordinary civil court. Civil court of original jurisdiction. In order to attract the jurisdiction of the special forum, it must be an ordinary transaction of a merchant. Similarly, my lord, your lordship, ordinary transaction of merchants, then comma, bankers. Similarly, financiers and traders, such as those relating to mercantile documents, comma, including enforcement and interpretation of such documents.
What is a mercantile document?
Oh, that has been interpreted by one of our division bench in Spice of Joy. A division bench of our Honorable Court has defined what is mercantile document. So instead of me interpreting that, I think if we refer to that judgment, spice of joy to them. Just Lordship kindly gives me a moment. Spice of joy টা কোথায় গেল?
Where is this restaurant?
This is possibly in Gold Park.
Gold Park.
In the Anwasha Road connector from
Mr. Dutt, did you get your book back? Not yet. You've got it back.
তা পাওয়ার না কি ছিল ওটা?
Anwasha Road.
from Jadavpur Thana to
So you're the only foodie.
Yeah, boss. Oh, absolute,
I use
complete.
that road to go to bypass, so that's why I've seen.
He's a foodie as well. Well, your Lordship is looking at 2022 SCC Online Calcutta 3010.
Yes.
Lordship kindly takes. Lord, here, if your Lordship will kindly see the facts. The present appeal arises out of a judgment and order dated 11th of November 2021, passed by the learned judge, Commercial Court at Alipur, in money suit number such and such, whereby and whereunder an application and order 7 of the Code of Civil Procedure was disposed of, directing the return of plaint to be presented before the competent court. Then, my lord, kindly take. My lord, 21C commercial dispute has been defined, and thereafter, my lord, paragraph 5, it takes into consideration that mercantile document has not been defined in the act, and therefore ordinary meaning is required to be assigned, and the reference have been made to a definition in Black's Law
This
Dictionary.
is all argument. This is
Yes,
all
these are
argument.
arguments. Yes, my lord. Then, my lord, kindly take
Paragraph seven.
paragraph 6. Paragraph 6. Then, my lord, kindly take reverting to the core issue at para 7. The eventuality enshrined in clause 21CI of the Act postulates that the dispute arising of the ordinary transaction of finance relating to mercantile documents, including enforceability, interpretation, and important factors, are to be borne in mind. The said clause can be segregated in 3 parts. Firstly, the dispute must arise out of an ordinary transaction of finance. Secondly, such ordinary transaction must relate to a mercantile document. And thirdly, the enforceability and interpretation of the document is involved. Then, my lord, a few lines after that, where the sentence after the parties are not ad item, then the mercantile document is not defined. Then, my lord, para 8, referring to Black's Law Dictionary, it says mercantile includes the transaction which is of commercial nature. The commercial paper is also defined in commercial Black's Law. An instrument other than cash for the payment of money, typically existing in the form of draft, check. Thereafter, my lord, then Stroud's Law Dictionary is considered in para 9. Then the Bombay view, then, my lord, our single bench judgment in the case of Lady Moon is considered, where, my lord, our court has held that a single solitary transaction of loan would not qualify to be a commercial dispute.
Well,
Lord, kindly once consider para 11. Para 11. The para 11, it says, my lord, if your lordship will take the second sentence at para 11.
court held it to be a commercial dispute.
On the facts of that case, and the facts of that case.
We
my
have
lord,
gone through the paragraphs, Mr. Bose.
if I may just paste one sentence from para 11, it says, in the instant matter, the respondent number 1 is admittedly running a multi-cuisine restaurant and bar and selling its products for profit. The appellant is a non-banking financial company and engaged in a business of financing or extending financial support and making profit from the same. Any money given on loan is an ordinary transaction of the non-banking financial company, provided it augments income for such transactions. The respondent number 1 who's selling the product for profit is a merchant, and therefore the transaction between the plaintiff who's engaged in the financing business extending the loan for profit is a transaction between a financier and a merchant. My lord, now applying that principle to the facts of our case, your lordship will see neither the defendant number, these are all individuals. The only thing it says in the plaint, nowhere in the document, there is no transaction for lending the money. There's a mortgage deed. A money has been given, no doubt about the fact they have been able to make out a case in the plaint, money has been given. So the issue is giving money itself. And by saying in the or making an averment in the plaint that I have given the money for commercial purpose.
The mortgage deed also says so.
My lord, it does. My lord, the mortgage deed is what, my lord? What we say.
Anyway, you make your submission, Mr. Bose.
What mortgage deed says, if you lord.
Yes.
My lord, what the mortgage deed says is, if I may just trouble your lordship with the mortgage deed once, it says that the mortgage is effectively starts from page 84. If your lordship kindly comes to page 91.
Business loan.
Yes.
It's a business loan,
Business loan.
but not commercial.
No, what I say, if I say it is a business loan, does it come within the purview of the act? That's what I'm trying to
We'll
say.
consider that. You have shown us the
Yes,
statute.
my lord. And my lord, if your lordship will also kindly see ordinary transaction. So, my lord, this ordinary transaction has to be.
We'll give a meaning to that word.
Yes. That ordinary
worry.
transaction means a transaction which the plaintiff or the person who has given the loan is engaged in its ordinary course of business. Only then it will be ordinary transaction of merchants. And my lord, so far as their second case is concerned, that for agreements relating to immovable property.
An ordinary mercantile transaction,
Yes.
not necessarily the ordinary business of the plaintiff. That's a way of reading it.
Yes.
So we'll see, we'll consider.
So, my lord, in my respectful submission, whichever way one reads Roman 1, my lord, the object of Roman 1 is those merchants. Merchants means merchants would be regular ordinary transaction of merchants. So merchants are people who are engaged in business. If you are an ordinary, some transaction happen, which is in your ordinary course of business, that would also constitute a commercial dispute. Dispute between two traders. Dispute between a retailer and a distributor. It would constitute a commercial dispute. What I am respectfully submitting is this is a transaction of loan. Now, in order to substantiate that this transaction of loan is an ordinary transaction, So he has to then come not as a merchant, but he has to come as a banker or a financer. So he is neither. There is no pleading in the plaint that he is either a non-banking financial company like the one that was there in this case of Spice of Joy, nor has he made out a case that he has any bank money lending license or he is registered with the Reserve Bank of India as a non-banking financial company. No averment in the plaint whatsoever to suggest that he is in the business of lending money. If you're not in the business of lending money, then you don't come under the purview of Roman 1. Then my respectful submission so far as Roman 7 is concerned, but they say that they also come within the purview of Roman 7, which is agreements relating to immovable property used exclusively in trade or commerce. So the word is used. So in Ambalal Sarabai, Supreme Court has held used doesn't mean to be used, intended to be used. Property given for the purpose of use. He said that it has to be actually used. The word is actually used on the date when the suit is filed, when the action is brought before the commercial court. No such case made out. Nowhere has, on the contrary, your mortgage deed says that, my lord, mortgage without possession, that plaint says that, mortgage says that, and your lordship will say they refer to a development agreement. The possession is with the developer. They say that they have cancelled the development agreement 1 to 32. So some of the owners have cancelled the development agreement. So the mortgage deed does not remotely suggest that the property is used for commercial purpose. You have to show it that it is how it is being used. Just merely saying it is used, that does not. I'll just show you, lordship, 2 paragraphs from Ambalal Sarabai. This is 2020, 15 Supreme Court cases, page 585. And then Supreme Court, the concurring view of Justice Bhanumati says, if this kind of certain interpretations are given to the definitions of the Commercial Courts Act, it will expand the scope of the commercial disputes. Well, that is not the object. That is not the object. It's expansive. If your lordship will take page 585, the first part is Justice Bopanna's judgment. Then that starts at page 589. Following a Gujarat division bench at para 11, kindly come to para 11. This view as the Gujarat division bench view has been affirmed. Para 11. On the other hand, the learned senior advocate for the respondents had relied upon a decision of a division bench of the Gujarat High Court in such and such, wherein a detailed consideration has been made and the conclusion reached therein by taking note of an earlier decision is that on a plain reading of 21C of the Commercial Courts Act, the expression used must mean actually used or been used. It is further explained that in the intention of the legislature was to expand the scope. In that case, the phraseology likely to be used or to be used would have been employed. The verbatim consideration there is as follows. Then, my lord, if your lordship will say, my lord, if your lordship will kindly come to Placitum E at page 593, the view of the Gujarat High Court which has been affirmed. Placitum E at 593. As per the agreement between the party, after getting the plots on lease from GIDC, the same was required to be thereafter developed by the original defendant number 1. And after providing all infrastructural facility and subplotting it, the same is required to be given to other person like the original. It is the case on behalf of the original plaintiff that as the original defendant has failed to provide any infrastructure facility and develop the plots, and therefore a civil suit for specific performance of the agreement has been filed. There are other alternative prayer. Therefore, it cannot be said that the agreement is as such relating to immovable property used exclusively for trade or commerce. It is the case on behalf of the original plaintiff that as in clause Roman 7 of 2C, the phraseology used is not actually used or being used, and therefore even if at present the plot is not used, even if it is likely to be used even in future, in that case also 2C Roman 7 shall be applicable, and therefore the commercial code would have jurisdiction. The aforesaid has no substance. As per the cardinal principle of law, while interpreting a particular statute or the provision, the literal and strict interpretation has to be applied. It may be noted that the important words used in the relevant provisions are immovable property used exclusively in trade or commerce. If the submission of the original point of the statute, which is not there in the statute, which is not permissible, on a plain reading of the relevant clause, it is clear that the expression used must mean actually used or been used. If the intention of the legislator was to expand the scope, in that case, the phraseology used should have been such and such, actually used, not to be used. Then, my lord, if your lordship will see, para 12, they agree to the view of the division bench. Then, my lord, at para 14, plaint was returned. Now, my lord, kindly take the concurring part of the judgment of Justice Bhanumati. I just wish to draw your attention to two paragraphs, paragraph 36 and 37 at page 602. para 36 and 37. A perusal of the statement of objects and reasons of the Commercial Courts Act and the various amendments to the Civil Procedure Code and the insertion of new rules to the code applicable to suits and commercial disputes show that it has been enacted for the purpose of overriding or providing an early disposal of high-value commercial disputes. A purposive interpretation of the statement on objects and reasons and various amendments to the Civil Procedure Code leaves no room for doubt that the provisions of the Act require to be strictly construed. If the provisions are given a liberal interpretation, the object behind the constitution of the commercial division of the courts, putting the matter on fast track and speedy resolution of commercial disputes, will be defeated. If we take a closer look at the statement on object and the reasons, words such as early and speedy have been incorporated and reiterated. The object shall be fulfilled only if the provision of the Act is interpreted in a narrow sense and not hampered by the usual procedural delays plaguing our traditional legal system.
Yes.
So then, Supreme Court is of the view, object and reasons, narrow interpretation has to be given. Expansive interpretation of 1C is not called for.
What else?
No, these are my respectful submission. And Lady Moon also, my lord, similar situation had arisen in the case of Lady Moon,
so,
which is a
said
single
so.
bench judgment, which have not.
Anything in reply, Mr. Gupta or Mr. Mitra?
One judgment has given that it has to be demurrer, and there's one more division bench which
Yes.
we had cited before Justice Sen.
Allahabad ka tha.
Division presented by Justice Sen. One I have given is Judge Chakraborty's division bench judgment, Lord Griham matter. It has to be demurrer. At that stage, the court can't investigate. And I have given one more judgment of our division bench.
With your notes you have given.
No, it's not with the notes. We had given a loose copy, Guralal Sheel. I can
Gura or Ghoda?
G-O-R-A, as in Rabindranath Gora.
My lord, there's one point I had, my lord, regarding the return of plaint. My lord, since it is a subject jurisdiction.
And we have not claimed anything against him. He's not he's a pro forma defendant.
That we saw.
My lord, since it is a subject matter jurisdiction, my lord, there's a full bench of Allahabad High Court which says, my lord, only in case of territorial pecuniary, court has the power under Order 7, Rule 10 to return. If it is a subject jurisdiction issue, it has to be rejected.
Here what has happened?
My lord, this has been, it says disposed of. So plaint effectively has been rejected. So because your lordship was of the view.
Give
Yes,
whatever.
kindly see,
We've
kindly
had
see.
enough of this matter, Mr. Bose.
This is AIR 1930 Allahabad, page 193. Which. If your lordship kindly comes to page 507. The para starts there. If your lordship turns to 508, towards the middle of page 508.
Very interesting. Justice Suleiman, Justice Mukherjee, Justice King.
Amitabh Bachchan, Vinod Khanna, and Rishi Kapoor.
Yes, 507.
At 508 was the middle of page 508.
Shashi Kapoor. Shashi Kapoor. Shashi Kapoor.
My lord, the para starting, where it is found that on the allegations made in the plaint, the suit is cognizable by the court, it will have to proceed to find whether the facts alleged in the plaint are established or not. If it is found on a trial on the merits, so far as this issue of jurisdiction goes, that the facts alleged by the plaintiff are not true, and the facts alleged by the defendant are true, and that the case is not cognizable by the court, there will be two kinds of orders to be passed. If the jurisdiction is only relating to territorial or pecuniary limits, the plaint will be ordered to be returned for presentation to the proper court. If, on the other hand, it is found that, having regard to the nature in the suit, it is not cognizable by the class of court to which the court belongs, the plaintiff's suit will have to be dismissed in its entirety. So, well,
Very good.
see, if it is a subject matter, if doesn't fall within the class of suit which the commercial court has the authority to receive, then it has no other option but to reject it.
If it is found on a trial,
Yes. No, my lord, here your lordship will see, not on a trial, my lord, if it is, my lord, this was a situation, if on the other hand, if it is found that having regard to the nature of the suit, it is not cognizable by the class of court to which the court belongs. So, my lord,
dismiss.
no, but that is reject. That means
Reject.
suit is dismissed. We are on the rejection part. Your lordship will see, then the suit has to be dismissed in the entire. I am here. I am saying that at the demurrable stage, when I say you don't have jurisdiction, this is not a commercial dispute. So if the court comes to a conclusion that it is not, what is the options available to the court? Will it return it or reject it? So in my respectful submission, it has no other
The division
alternative.
bench was placed before us,
Yes.
where it was just returned to be represented before the ordinary original jurisdiction. Jashi show mentions. এই ব্যাটারটা আছে আমাদের কাছে মনে আছে 4 মাস সময় দিল 4 সপ্তাহ There's a division bench of this court. Anyway, this is a minor thing.
Yes.
Let us first decide whether it's a commercial dispute
Absolutely.
or not.
I will not multiply anything more because the judgment is here,
Very
but
good.
the one division bench is good enough as good as.
Which is that one? খুঁজে বার করতে
My
Did you
One is in my note, but the other one,
Yes.
I can just hand up the
কি আছে দেখান তো কি দিয়েছে লুজ দিয়েছেন বলছেন
the notes has been given with the
The note we have.
I remember citing it for Justice Sen, but I don't see any paper here. Goralal Shield, no, that is not there. That is not.
ওটা না
No, this is not good.
Got a. Well, Lordship can just see once. There also Ambalal Sarabhai was.
হ্যাঁ এটা আমার মনে হচ্ছে লিখতে শুরু করেছি
I will give a printout today itself. Well,
So Goralal she'll just hand over a copy,
it has-
2 copies
paragraph
today.
And my lord, your
paragraph
lordship
14
can-
of the judge.
The lordship can also consider a division bench of Bombay, which also says, my lord, subject matter jurisdiction. If that,
Mr.
Then
This is
return.
irrelevant if there's a Kolkata
of course.
division bench.
my lord, Allahabad was a full bench, not considered by our division bench.
Doesn't matter. We can't say our division bench was wrong. We can differ.
No, if
You can
if your
differ.
lordship will see, if there is a full bench which was not considered by the division bench,
Yes.
Yeah, Allahabad full bench, Allahabad full bench, which in fact has been uh, pre. There is a Supreme Court which affirms that Allahabad full bench.
Yeah, you can. Persuasive. Yes, hearing is concluded, judgment is reserved.
Division bench has returned a.
So, give my money, I will withdraw my suit. I will withdraw. Give me my money, I will withdraw my suit. I will not.
Oh, I see. You're for 1 to 32.
Principal court.
Principal borrower, give my money, I will withdraw here.
Supreme Court doesn't mean. Good.
এই ওটা হিয়ারিং কনক্লুড করার আগে একটা লাইন লিখে নাও, মনে থাকবে না। Mr. Moinak Bose, learned senior advocate representing the defendant number 41, concludes his submission. Paragraph, learned advocate for the respondent numbers 1 to 32. Respondent numbers 1 to 32. In this appeal, respondent number says that the said respondents do not object to the plaintiff's claim, do not oppose the plaintiff's claim, and have accordingly filed a written statement to that effect. Stop. Paragraph, we note his argument. Stop. Paragraph, hearing is concluded, judgment is reserved.
Well, maybe file a note by Monday. If
You need to. If you want to. We are not asking. If you want to, you may file. তাহলে reserve করোনা. Hearing is concluded. Stop. List this matter once again on Monday date though.
Monday, or should it be next Thursday?
Huh?
We'll have a week's time.
Next Thursday
Next
date.
Thursday. Great.
Point is we'll forget. Try Tuesday.
Tuesday, very well.
Tuesday time
Tuesday,
though.
Tuesday.
Under the heading to be mentioned, comma, as requested by learned advocate for the defendant number 41, comma, only to enable the said defendant to file his written notes of argument. Appellant. Did we hear it before? No, first time.
No, first time. Refusal to pass, my lord, the interim order. First day, my lord, I have served. Though I was not required to, but I have served. Sorry. 4-5. I'm sorry.
Three lordship.
This is 3.
Very sorry. I apologize for. Sorry.
Yes,
Item number 3, I'm praying for a day's accommodation lordship.
for the appellant.
For the appellant lordship. Mr. Supratim Dhar is appearing for the appellant. He's on his legs, your lordship.
He is for the appellant or
Appellant.
on the prayer made on behalf of the appellant, comma, let this matter stand adjourned for the day.
Item number 4.
My lord, here, my lord, I am for the appellant. Before I proceed, I'm sorry, my lord. I apologize for what I did in the earlier matter, and I also apologize, my lord, for what I submitted day before yesterday, my lord. About, my lord, the decision taken by the bar, my lord, I said that a decision was taken not to attend.
Yes.
I
Yes.
was, my lord, just before coming to court, my lord, what I received was that it's a not to attend.
But it was not to pass adverse orders if all parties are not. Effectively the same, Mr. Mitro. Not all parties were present.
Still, my lord, I ought not to have said that.
Yes, we saw the resolution once we got back to our respective chambers. Yes, affidavit of service have you filed?
Your Lordship, I'm appearing for the respondents. Your Lordship, still allotment has not been taken place from Ministry of Law and Justice. I was beseeching if it could be taken up on Monday.
My lord, I'll tell you, your lordships, my lord, the whole difficulty is, my lord, railway. I shall give the background, my lord. Railway, my lord, gave me a contract, my lord, to manufacture and supply slippers, a particular type of slippers.
Also
longer.
allotted land.
No. Contract provided that land would be allotted. And my lord, the contract, then my lord, the land was allotted for setting up the factory.
10% increase of license fee.
10% of increase of license, my lord. In that process, it was about, my lord, 10 lakhs last. 10 lakhs or 13
Now
lakhs?
they claim 43 lakhs.
43 lakhs. Now, my lord, today, my lord, the matter is pending before if your lordship see the first order of the, my lord.
They have already terminated your contract, no?
No. I am just, my lord, seeking that protection. We can go back before the court below and, my lord, fight it out.
Because the first order
Yes,
was a detailed order.
absolutely.
Only thing is the judge said that I'll consider on the next date.
Because, my lord,
She was under transfer possibly.
on the second day,
On the
yes.
second day. এটা আমি পড়েছি। Yes.
Your Lordship, kindly take it up on Monday.
No, but before Monday, what if you terminate?
Your Lordship, still officially nobody has been engaged in this matter. If it's taken ex parte, I would not say anything, but I have only been instructed to adjourn it for Monday.
Which is the appeal against this?
Well, Lord, there are two appeals from both the orders.
এই দাও না আমাকে দিন দুটো মেমো দিন দুটো মেমোই
AO3 is
দিন
from the second order. AOCOM number 3 is from the second order.
Oh, 80 subsection 2
Yes.
without giving an opportunity, no interim order. EPC. That is why. And on the next date, this is on the transfer.
On transfer.
Prayer for adjournment allowed. Issue. Very well. You come back on Monday, but in the meantime, a limited protection. একসঙ্গে করবে দুটো appeal.
Well, can it be Tuesday instead of Monday?
Yes. These two appeals are directed against orders dated
7th
April
April
7.
2025 and 11th April.
April 7, 2025 and April 11, 2025, passed by the learned judge, commercial court at Rajarhat in TS -8 of 2025. Stop. Paragraph. The plaintiff's case is that it was the successful tenderer for supplying PSC sleepers for broad gauge to Eastern Railways. Eastern Railways.
Yes.
Stop. As per the terms of the agreement, The plaintiff was granted a plot of land for the purpose of establishing a factory for manufacturing the sleepers. Stop. The plaintiff took possession of the land in May, 2003 and has been paying the license fee regularly. Stop. Paragraph. The plaintiff says that the agreement was that every year license fee will be enhanced by 10%. 7%. Stop. Suddenly, on March 28, 2024, the plaintiff received a provisional demand notice for a sum of rupees 47,32,812 for the period 2023-2024. Stop. Paragraph. The plaintiff protested to such inflated demand. Stop. However, the railways have not withdrawn such demand. Stop. Apprehending that the railways may terminate the subsisting contract, the plaintiff approached the learned commercial court at Rajarhat by filing the instant suit, praying for dispensation of the pre-institution mediation under Section 12, capital A of the Commercial Courts Act, 2015. The plaintiff also prayed for leave to institute the suit without serving notice as required under Section 80(1) CPC. The learned judge granted leave under Section 80(1) CPC as also dispensed with the requirement under Section 12, capital A of the Commercial Courts Act, 2015. Stop. However, the learned judge observed that before passing any order on the injunction of the application which the plaintiff had filed, an opportunity should be given to the defendant, being government, to make submission as required by Section 80(2) CPC. Stop. Paragraph. Accordingly, the learned judge directed issuance of notice and listing of the matter on April 11, 2025. Paragraph. On April 11, 2025, prayer was made on behalf of the defendants in the suit for time to file written objection prayer was made for adjournment and for time to file written stop. The learned judge recorded that she was under order of transfer and allowed the prayer for adjournment, fixing June 9, 2025 as the date for hearing of the injunction application. So, being aggrieved, the plaintiff is before us by way of the aforesaid two appeals. Paragraph. Learned advocate for the respondents prays for accommodation. Stop. Let this matter be listed again on Tuesday, date thou paragraph. However, comma, we find from the facts briefly narrated above, comma, that the plaintiff has made out a prima facie case. Stop. Apparently, there does not appear to be any basis for the inflated demand for license fee by the railways. Stop. Of course, this is a prima facie observation. Stop. The balance of convenience also appears to be in favor of the plaintiff for passing a limited protective order. Paragraph. আজ কত তারিখ? 1st May. Till May 8, 2025, or that's next Thursday, or until further order, whichever is earlier, no coercive action shall be taken by the respondents against the appellant in respect of the subject contract. You have heard?
Your Lordship, kindly record my submission that no formal engagement has happened from Ministry till now for learned advocate.
Accommodation on the ground that no formal engagement, on the ground that the Ministry of Law has not yet engaged a lawyer in this matter. ঠিক আছে তো?
হ্যাঁ 4 and 5.
4 and 5. Oh, subordinate.
লুটটা খুলে দাও বিলটা খুলে দাও আমার
We remember, Mr. Shah, subordinated.
yes
Debt.
this is the buller carted matter subordinated buller carted
Yes.
only matter the 9th
We had
April-
suggested also, we had
yes
expressed our thoughts that we'll remand it, send it back, requesting the court to decide the issue within 3 months. And for those 3 months, the EMI that you are now paying, you will continue to pay. Nothing more. Yes. Please, please. Yes, please. Yes, yes, of course, we must hear you.
My issue of maintainability kindly also hear us,
Maintainability of?
the 2 appeals. Of the
Can
2
you
appeals.
know why?
Because on the first instance, I indicated to your lordship that the order which has been passed does not come with the order 43.
Order 39, order 39 rules 1 and
That I will try to converse before your lordship.
Yes, anything more, Mr. Shah? We remember.
nothing only my lord 9th April order against which the second appeal has been filed there my lord the application for extension of the interim order was made but my lord admittedly it was not served on me but the interim order was extended that's just my lord one thing my lord I wanted to
Yes.
The first appeal pertains to 2 orders, that is 26 March 2025 and 8th of April. Now on that day, the intervention application was fixed. On a single day, multiple applications were
IDFCs.
fixed of IDFC. That was being taken up. It had fallen from Mr. Shaha also that they were hard. IDFC were hard, though they were not parties. Only writing a clause word that IDFC Bank the application filed by the IDFC Bank Limited as well as injunction application will not make this order an order which comes under order 43. Kindly sees this second paragraph also. The third paragraph, the learned advocate for the defendant number 1, 26 March order, page 44 on the memo in. The learned advocate for the defendant number 1 appears and files a hazira along with an application praying for time to file a written objection to the intervention application. That is IA number 4 in the instant suit on the ground stated therein. The learned advocate for the intervener IDFC Bank Limited appears and files a hazira and affidavit of service such and such. Heard the advocates for the respective parties, then the case record is now taken up for the hearing of the intervention application as well as the injunction application. So kindly sees the orders thereafter. Entirely IDFC Bank was heard, injunction order was never taken up. Kindly see, at the time of hearing, it is submitted on behalf of the intervener that none of all the factual allegations made by the plaintiff petitioner in the injunction petition is admitted. The intervener is not interested to be added as a party in the instance suit, as he is neither a necessary party nor a proper party in the suit. He is not also interested to the fate of the suit. The fact remains that the plaintiff owes a sum of rupees 25 crores, which it I'm led by Mr.
They come in 1 minute, madam. I have 1 minute of it.
Please,
Led by Mr. Banerjee. He has come.
you decide whoever.
My lord, on the last day, I showed that the order which was to be appealed against is not before my lord. On the last day also, I showed my lord that this is not an appealable order. Because of the Commercial Courts Act coming in, my lord. Today also, I'm saying it's not an appealable order. Before I show my lord the order, kindly sees the provisions. Kindly takes my lord once the Commercial Courts Act, section 8, my lord. And then I'll show the orders which Mr. Dashgupta was, my lord, reading before, my lord. Kindly takes, my lord, section 8 once, my lord. Lord, kindly sees there is a bar with regard to revision as well as appeal, my lord. Bar against revision application or petition against an interlocutory order, notwithstanding anything contained in any other law for the time being in force, no civil revision application or petition shall be entertained against an interlocutory order of a commercial court, including an order on the issue of jurisdiction, and such challenge subject to the provisions of section 13 shall be raised only in appeal against the decree of the commercial court. Now, my lord, revision is subject to section 13. It's not, my lord, as a matter of right. Now, my lord, kindly take section 13 once. Kindly takes 13. Appeals from decrees of commercial courts and commercial division. Any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment on order. This is the period. Now, my lord, kindly takes, my lord. Any person aggrieved by the judgment on order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be commercial division or high court, may appeal to the commercial appellate division of the high court within a period of 60 days from the date of the order. Then, my lord, proviso, provided that an appeal shall lie from such orders passed by the commercial division or a commercial court that are specifically enumerated under order 43 of the Code of Civil Procedure, as amended by this Act, and section 37 of the Arbitration and Conciliation Act 1996, not otherwise. So, my lord, kindly sees now order 43. How does he qualify? My lord, kindly takes order 43 of the CPC, my lord. Because, my lord, commercial court is a very restricted court, my lord. Because, my lord, we can't even file a written statement beyond the time period if it is over, my lord. Kindly see 43 now. An appeal shall lie from the following orders under the provisions of section 104, namely, an order under Rule 10 of Order 7, returning of plaint. Then, my lord, kindly sees, my lord, C, an order under Rule 9 of Order 9, rejecting an application. Then, my lord, D, an order under Rule 13, Order 9.
Mr. Please don't read the entire
I
list.
don't need to, my lord.
R, only read R.
Yes, ma, kindly sees R also, my lord. An order under Rule 1 and 2 and Rule 4 of Rule 10 of the Order 39. Now, my lord, where does it, my lord, qualify under Order 39? My lord, the first order, as Mr. Dasgupta was reading, was of 26th of, my lord, March 2025. That was the first order. My lord, kindly sees, my lord, what is the order? Today it is fixed for hearing of the instant intervening application filed by IDFC as well as injunction application. This injunction application is my learned friend's injunction application before the Honorable Court. This is not any injunction application filed by any of us. And this injunction application, my lord, was only kept on the record. No hearing was done. Kindly sees no orders passed in that injunction application. This cannot be construed, my lord, as an order passed under Order 39, Rule 1 and 2. This is merely a recording that on that day, on the board, my lord, the injunction application was also appearing. Now, kindly sees, mother, the last part of this order. After hearing the learned advocates for all the respective parties, mother, that's at page 44, my lord. Kindly takes page 44. Yeah. Well, kindly takes, my lord, page 44. The last paragraph. After hearing the learned advocates for the respective parties as well as the intervener, it appears that the defendant respondent should continue to pay the loan installment, if any, by EMI or otherwise till the date fixed. This order is made for the ends of justice in light of the order passed by the Honorable High Court. Accordingly, it is observed that till disposal of the injunction petition, there is no restriction or restraining order upon the defendant to pay the EMI, if any, to the intervener till the next date, that is 8/4/2025. So there is no order passed in the injunction application. This is an order passed in the intervention application. That does not qualify, my lord, under R. Kindly see page 45. Next order table, page number. Huh? Volume 1. Actually, volume 1. Page 44 of volume 1, my lord.
What?
My lord, the order, my lord. My lord's officers were. My lord, page 45 records, it's an order passed in the intervening application.
Item 7.
No, notun memo.
Yes, next.
Now, my lord, kindly takes the next order, which is 8th of April 2025. Again, my lord, kindly sees what is recorded. Kindly sees, my lord, at the heading itself. Today is the matter fixed for intervention application being such and such, as well as injunction application. That is all. There is no order passed in injunction application which qualifies, my lord, an appeal under, my lord, before this court under section 13 of the Commercial Courts Act. Now, my lord, kindly sees the order. Finally, my lord, kindly takes page 47. Or, my lord, kindly sees the ordering portion at page 48 itself. Let the order number 11 dated 26 March 2005 be modified in paragraph 8, line 6, according to the word plaintiff instead of defendant number 1, fix 9/4/2025 for hearing of order 37, rule 6. So what is the order, my lord? The order is, my lord, only a mere correction and fixing of the other application, my lord, on the date that is 9/4. There is no order passed on, my lord, this date. Kindly sees the ordering portion. It's a correction made to the order of 26 March 2025. No order pass. Well, how will an appeal lie when there is no order passed with regard to order 39, rule 1? Next, my lord, kindly comes to 9th of April.
Yes. We have it in front of us.
Now, my lord, kindly sees today is the matter fixed for hearing of Order 37 Rule 36 of the CPC along with the injunction application and pro inter se application. So every day, my lord, if a GA is filed along with a plaint, my lord, it would appear in the list. My lord, unless an order pass, it does not qualify him for an appeal under, my lord, section 13. My lord, this order also kindly sees, my lord, the matter is only fixed on 24th of June 2025. No order has been passed. And my lord, kindly takes their pleading itself at page 60, page 16, paragraph 53. They themselves have admitted it also. Kindly takes it, my lord. My lord, kindly takes paragraph 53, page 16 of their, the present appeal, my lord. They themselves have admitted it. This is an appeal from that order. The Lordship has got it, my lord. Page 16, paragraph 53. The matter was thereafter listed on 9th of April 2025 for consideration of the application under Order 37 Rule 36 of the CPC. They themselves are saying that there is no interim application which was heard on that day. So, my lord, then how is the appeal maintainable, my lord, before my lord, under section 30?
Next point, Mr. Banerjee.
This is, my lord, my preliminary point, my lord. With regard to the other part, my lord, that is between IDFC and them.
So let us then hear him.
My lord, kindly hears him. My lord, there is a judgment of this honorable court. May I just, my lord, show it once, my lord?
Division bench.
Division bench, my lord. Copy the copy. Or kindly sees the last paragraph, my lord, in this particular, my lord, first page itself. We must remember that the right of appeal emanates from the statute. A party cannot assume the remedy by way of an appeal if the statute does not provide. Section 13 of the Commercial Courts Act 2025 contains an exhaustive provision relating to remedy by way of an appeal in favor of a person aggrieved by the judgment and order of the Commercial Court Act of 28 of 2018. The original subsection 1 have been reintroduced with certain amendments, more particularly incorporating section 1 capital A with the proviso added thereto. It is beyond cavil of doubt that any person aggrieved by a judgment and order of commercial court may appeal to a commercial appellate court out of the period of limitation provided therein. But if the appeal is filed against an order passed by the commercial division or commercial court, it must satisfy that such order is amenable to be challenged by way of an appeal under Order 43 of the Code of Civil Procedure and Section 37 of the Arbitration and Conciliation Act 1996.
Agreed, Mr. Banerjee.
So therefore,
Absolutely agreed.
my lord, greatest of respect, my lord, there was no order passed under Order 39.
We are not necessarily agreeing with you. We are in agreement with this proposition.
I am saying, my lord, Lordship, my lord,
Mr.
could try, my lord, to consider this, my lord, once that there has been no order passed on the application.
We will see that. We will see that.
Kindly,
whether passed or not passed.
Grateful, my lord.
Please, your lordships, my lord, I'll enter into the merits directly. I'll not taking any technical points. I'll indicate, my lord, very briefly what the matter is in 5 minutes before I indicate my points. Lord, my client was not a party to this dispute. It's between the plaintiff and the defendants. Plaintiff advanced a loan. Defendant faulted in repaying the loan. We were not made parties. Dominus litis is the plaintiff. Plaintiff was well aware that if we are in any manner involved, we would be made a party. So according to the plaintiff, we presume that the plaintiff knew that we are neither necessary nor proper parties. Proceeded with the matter. Sought for an injunction. Injunction was granted.
Why would the plaintiff necessarily know of your existence or involvement in the matter? Pleading.
Thereafter indicate the same. And I'll indicate why and how it panned out. We were not made a parties there. It's a simpliciter money suit where the plaintiff says, I've given a loan. They have defaulted. I want my money secure and I want that money back.
with interest. That's the case. We were not made a parties there. Subsequently, an order is passed. This is where we get affected. One line of that order I'll indicate, and I'll indicate what is the essence. Why is it that the December order affected us? We came to know of an appeal filed by the defendant before this honorable court. It was heard by the division bench of this honorable court. A challenge to that interim order. Here in that appeal, we tried to intervene. But we came to know at the very last moment, so we could not come up with an application. Our point was very simple. We came and indicated before the honorable court. We are not parties there in that proceeding. Kindly see this one line of the order, which I'll indicate. The order read that one line. You will not, till you repay the entire sum to the plaintiff, you will not be paying any other creditor. Any other creditor. It was an action in rem. In a suit in personam, an action and order passed in rem. We got affected. How? Because the plaintiff had advanced a loan of around 18 crores to the defendant, where the defendant defaulted. We advanced a loan of 25 crores to the defendant, and our rights would be affected because it would induce a breach of our contract. We are not privy to this contract, which is an issue. That is why the application which we filed later was an application pro inter SSO. We still contend that we do not want to be added as a party. We have nothing with this dispute. We are not privy to this contract. But our rights are required to be safeguarded by the honorable court. Hence, an application under pro inter SSO. I'll indicate that application as a very limited premise. We are affected by that one line. We were affected by that one line of the order. And the reason is this. In our loan, which we have disbursed of 25 crores, there is an EMI which is being repaid, which is around 35 lakhs per month. 35 lakhs per month. 1st of May, that's today, is the entire repayment which falls due. So it has fallen due today. My cause of action for an independent suit has arisen from today. If they do not make that payment and they take shield of an order of a court saying that because of this order, will not repay your entire amount. Today, the very essence of the submission which is being made by my learned senior friend for the appellant is that if they make this repayment, then our amount will not be paid, and it was indicated on the last day that they have a 10% shareholding. And
your claim is subordinate to their
I am
claim.
very grateful. That I'm carrying an RBI circular. This is not a proper. May I first indicate that circular and the definition of a subordinate debt when it comes into play. I'll submit that a subordinate debt, the subordination does not come when there's a case of breach of contract. Subject to being corrected by your lordships, the subordinate debt will only come into play in case of a liquidation proceeding or an insolvency proceeding. It's a tier 2 debt, which is May I only indicate, my lords, when the previous appeal was filed, since we did not have an application before the Honorable Court, our submissions were considered, and that's reflected in paragraph 18, which I'll indicate, of the Honorable Bench's order. That if this order is sustained, then it tantamounts to inducing a breach of a separate contract. And then the matter was relegated back to the Honorable Court, the Learned Trial Court.
That order was not interfered with.
That order was interfered with.
Right.
And I'll indicate how it was interfered with by referring to the order. It is at that junction that we filed the application pro inter SSO, because we were not served with a copy. Of course, we would not be with a copy of the plaint and the injunction, because we were not party to the proceedings. We filed an application pro inter SSO indicating these parts of the orders which affected our rights. The Learned Court considered the petition and modified that part of the order to the extent that it does not induce a breach of our contract with the respondent in the
So in effect, permitted them to pay the EMIs to you.
Permitted them to repay whatever was due in accordance with this agreement with us, which is not only the EMI, which is also the repayment which falls due today, 1st of May, which otherwise would be affected, because my rights will be then affected, the account will become NPA. So our rights will get affected, because we are counting on that funds to come back to us. Had this 10% shareholding, of course, I'll place reliance, your lordships are well aware of the judgment, but I'll still place reliance on Bachaev Gosdar. My being a shareholder will not mean that I'm in operation of the company. And had I, if my client would have any other intention, we would not have filed the petition pro inter SSO, because I would want that this order be continued for reasons that they don't have to make that repayment to me. It's an NBFC. The plaintiff is an NBFC. We are bank. NBFC cannot have a higher right than a bank, and the subordinate debt, I'll indicate from RBI circular, is nowhere to be considered in case of breach of a contract. The definition of subordinate debt is only that it comes into play when there is an insolvency or a bankruptcy proceeding. In fact, my learned senior friend had indicated yesterday, when the day before yesterday, when the submissions were being made, that this is an allegation of a related party, 10% shareholding. A related party is a concept only in IBC. It does not find favor in a contractual dispute where the contract is being breached, and that breach is being induced by an order of a court. Now, kindly permit me to indicate from my application and the annexures there too. I'll indicate 2 orders. Kindly take up, the application starts from volume 3 in item number 6. Volume 3, page 415.
Just 1 second. Let us see what we have,
my lords,
with us. AO5.
AO5, my lord. AO5, volume 3, page 415. This is where our application pro inter SSO starts. But kindly take up the first order by which we were aggrieved. It's at page 433. This is an order dated 23rd of December 2024. And may I very humbly submit, when we filed this petition, we did not have a copy of the plaint or the injunction petition. Now we have a copy of the injunction petition. I'll indicate from the injunction petition, paragraph 13, paragraph 25, that they were aware that IDFC Bank had an exposure. That's pleaded. That's their pleading. Kindly take up page 433. This is where the first order was passed by the Rajarhat Commercial Court. 23rd December 2024. Kindly take up one line by which we are aggrieved. Page 436. The third last paragraph, 436, it starts in the factual score. This is the third last paragraph of the page. Factual score before contested hearing on affidavits, it appears that the order of 19th December deserves to be modified to the extent that the defendant, respondent number 1, be restrained by an ad interim injunction order from making any payment. Kindly underline this. These three words, this is what we are agreed by. This phrase, to any creditor before the petitioner or the plaintiff's monetary overdues are cleared.
Very well. Next, what happened? You came up.
Now, kindly take up the division bench order. That's at page 438. The relevant part is paragraph 18 at 449.
They went up in appeal. The Mr. Banerjee's client.
They were the appellants here. Page 449, paragraph 18. The impugned order prima facie shows that preferential treatment. Page 449. Paragraph 18. The impugned order prima facie shows that preferential treatment was given to the plaintiff as regards repayment of the loan or advances by the plaintiff over other creditors. IDFC First Bank claims to be one of the creditors. That other creditors may be affected by an order cannot dilute the legal right of the plaintiff to secure its claim. In the event of establishing its legal right, notwithstanding, at the initial stage, the court should be circumspect not to pass any drastic order that may cause breach to any existing obligation of procuring a breach of contract. I pause here. This was the argument. This was my submission. Because this order, that line would induce the breach of our contract, to which the plaintiffs are not a party. Now kindly take up page 527. This is the sanction letter. Page 527.
No, so therefore what happened then? What was the...
It is then that we filed, my lord, it is then that we filed the pro interests suo. The interim order was varied, that's paragraph 19. Direction was really on the defendant.
Yes.
But thereafter, Lord, may I indicate the sanction letter directly? That's page 527. This is our sanction letter to ASA.
So you were not granted any protection as such.
That's because of another paragraph, my lord, which is where it is recorded that we did not have an application before the Honorable Court. Your Lordship will kindly take up paragraph 6, my lord. At page 441. Paragraph 6 at page 441. An attempt was made by the counsel appearing for one of the creditors to submit that the said order ought not to have been passed without hearing IDFC First Bank. However, in absence of any application, we are not inclined to go into that question. But paragraph 18 is my submission. That is what I had submitted. Lord, the sanction letter is at page 527. Kindly see, my lord, the facility. This is what has been submitted by my learned senior friend. Facility subordinated unsecured term loan at page 527. This is serial number 2. the second row. And facility amount is indicated up to rupees 25 crores. And the repayment schedule is over the page. Events of default is 529. This is an agreement between us, the petitioner in pro intercessor, and the defendant. Now, kindly, I'll pause here for a moment because I have to clarify what is a subordinated unsecured term loan. In terms of an RBI circular, kindly permit me, show me the photocopies. Quick. Photocopies of RBI circular, I told them. Give me the copies, please. Lord, I'm carrying the relevant page, which is the definition clause.
Do you have any security? You're holding any security for the loan?
We are both unsecured.
Both of us are unsecured.
Unsecured.
Both of us are unsecured. My lord, if it was security, then my lord, there would
Then
be.
I could not make this up.
Then my lord, it would
Then I
be my
could
lord,
not.
registered under section 77 of the Companies Act. And my lord, there my lord, the clear my lord, hierarchy my lord, of charges, my lord, first charge,
Why
second
should
charge.
your unsecured loan be secured?
I'm very grateful. That's
My lord, I'm not asking for security. I'm saying, my lord, that it has to be paid in preference.
Get a decree, execute it.
my lord, this
Lister and Stubbs starts from Lister and Stubbs, 45 Chancery Division. And then, of course, countless cases.
my lord, may I hand over one copy of the entire circular? My lord, what I've handed over is the page which I've flagged, page 233 of this entire circular. my lord.
What will we do with that?
I mean, it's only for reference because my lord, I've flagged that. I'm carrying only one copy. Kindly pardon me, my lord. But I've made copies of the relevant page. Your lordship will kindly take up the definition of a subordinated debt. It's in the middle of the page, my lord. Refers to the status of the debt in the event of the bankruptcy or liquidation of the debtor. Subordinated debt only has a secondary claim on repayments after other debt has been repaid. So it's only in the case of bankruptcy or liquidation. Give another copy to sir. It's only in this situation. It's not for a breach of contract. Now, my lord, kindly permit me to place reliance on another.
You've given Mr. Shah a copy?
Yes. My lord, may I hand over a definition of a subordinated debt? My lord, this is from a website called Investopedia. My lord, they define, my lord, financial terms. I'm only placing reliance on the fourth page, my lord. It's at the bottom, my lord, that the page number is indicated at the bottom right-hand corner. It's 4 out of 8. Subordinated debt versus a senior debt. Kindly see the first 2 lines, my lord. It's page 4 of 8 at the end, my lord, bottom right-hand corner. Subordinated debt versus senior debt.
Yes.
The difference between subordinated debt and a senior debt is the priority in which the debt claims are paid by a firm in bankruptcy or liquidation. The same definition, my lord. This is not an action in bankruptcy or liquidation. So subordinated debt as a concept will not be applicable. It will be applicable, my lord, in case of a liquidation, where a waterfall mechanism under section 52 is to be followed. This is not that case. This is my submission, my lord. Hence, subordinated debt will not really create a case for them.
Let us hear him again
My lord.
in reply.
This is, my lord, my brief submission. Also, my lord, that I should not, it's a very technical point because I'm pro-interest, so, my lord, not added as a formal party. So whether they can change the cause title, my lord, of the claim, but I understand it's an appeal, so I leave it to your lordships.
Will it permit me first to deal with Mr. Bag's portion of the arguments before I go on to the question of maintainability?
Maintainability, don't bother.
Very well. I'm so grateful. So grateful. Now, my lord, so far as my lord, I'm so grateful. Now, my lord, Mr. Bag's, my lord, submission principally rests my lord, on the merits of the matter. And my lord, I had, my lord, indicated to your lordship, my lord, that the merits of the matter have not been considered. What is a subordinated debt? Whether it applies only in the case of insolvency or liquidation or bankruptcy proceedings, or whether it will apply across the board, my lord, that has not been considered. And that is why, my lord, this, my lord, what had fallen from your lordships is perhaps that the first court should apply its mind. But my lord, I am more than happy, my lord, if your lordships, my lord, decide this question. So, my lord, may I just proceed very briefly, my lord, to indicate. My lord, my lord, my learned friends, entire basis of his submissions is, my lord, Reserve Bank of India, July 1, 2013 circular. Now, my lord, kindly see. My lord, permit me to place this. Please refer Master Circular number so-and-so, consolidating therein prudential guidelines issued to bank till the date on capital adequacy and market discipline, new capital adequacy framework. You are aware, Basel III capital regulations is being implemented in India with effect from April 1, 2013 in a phased manner. Malad, Basel III, Malad, these are, Malad, European regulations.
Basel is in Switzerland.
Yes, I think so.
No,
I'm not very familiar.
I know that.
Lordship. So,
Because I've been there. Yes.
so, Malad, as you are aware, Basel III regulations being implemented in India with effect from so-and-so, accordingly, instructions contained in the aforesaid Master Circular have been suitably updated, amended by incorporating relevant guidelines issued up to 30th June 2013 and is being issued as Master Circular Basel III Capital Regulations. Basel III guidelines as contained in the Master Circular number so-and-so dated on prudential guidelines and adequacy of market discipline so-and-so may, however, be referred to during the Basel III transition period. Kindly, may not mark this. Basel II guidelines contained in the Master Circular on prudential capital recognition so-and-so may, however, be referred to during the Basel III transition period for regulatory adjustment directions up to 31st March 2017. Thereafter, I find directly, page 283. I don't really know, whether it's a part of the same circular and what manner it comes in. But, kindly see these, assuming, of course, since Mr. Bagh has handed up, I'm sure he has, gone through the contents. But, this is, in respect of a circular of 1st July 2013. The circular which I have given to your lordships is of 2023. Now, kindly see this circular, which is, the circular in my respectful submission, which should hold the field. Kindly, have the circular once again. Where is it?
Page 3.
Volume 3, not 2. My lord, kindly first see. My lord, that was, my lord, the circular shown by Mr. Bagh is with regard to the implementation of the Basel regulations in India in a phased manner. But, my lord,
which is the one you are referring to?
I am referring to the circular at 390. Of page 390, volume 2.
This appeal.
Of this appeal. And this is, my lord, a 2023 circular. Updated on 27th February 2025. Kindly have page 390. It is, my lord, described as the master directions of Reserve Bank of India, NBFC based regulations. The respondent number 1 company, R1 company, is an NBFC. So these are the master circulars by which, my lord, they are bound. Respondent number 1 is bound, the company. Kindly, my lord, note over here that, my lord, there is no, my lord, indication that the definition of subordinated debt is, my lord, confined only, my lord, to liquidation proceedings or, my lord, bankruptcy or insolvency proceedings. In any event, my lord, kindly, my lord, appreciate that, my lord, in 2013, the circular which has been shown to your lordships of 2013, at that time, my lord, the insolvency code had not yet come in. It came in 2016. And under the insolvency code, my lord, now, my lord, there is no question of any, my lord. Once the company goes into insolvency, insolvency code term.
Yes, Mr. Shah.
My lord, may I divide, with your lordship permission, my argument in two parts?
No. You have shown us. We understand what you say. This has to be decided by the trial court. We don't have the time, not the inclination. So we will continue the order for 3 months. But tell us a more fundamental question.
Yes.
Why should we secure your pure money claim? What happens to the principle of law that a pure money claim will not be secured? If you can make out a case under Order 38, Rule 5, yes, go get attachment before judgment. Why should we secure a pure money claim?
My lord, so far as, my lord, securing of the money claim is concerned, my lord, your lordships have rightly raised that point. Now, my lord, so far as this company is concerned, my lord, your lordship will kindly see, they have, my lord, said.
Very well. We will send it back. This is a difficult question. Let the trial court consider it.
I'm grateful. I'm deeply obliged.
If-
But, my lord, just for academic reasons, if your lordship will indulge me for half a minute, my lord, what Mr. Bagh has said, really, my lord, it's very thought-provoking. But, my lord, your lordship will see, in effect, in law, and this, my lord, I'm giving him, my lord, a prelude to what, my lord, will perhaps we argued before. This July 13 circular cannot, my lord, be of effect today. Because, my lord, after the insolvency code has come in, if, my lord, at the CIRP, the insolvency stage, there is question of distribution of assets, then, my lord, the commercial wisdom, my lord, of the COC comes in. And if they say you will get 3 paisa and he will get 23 paisa, then the court can't intervene. So the RBI cannot decide, my lord, in what priority who will get. That's one. And, my lord, the second stage, my lord, at which distribution can arise is, my lord, at the liquidation stage. And at the liquidation stage, my lord, Section 53 will prevail.
Very well. Issue. Two appeal আছে একসঙ্গে. This is APO 5 is against the last order, 9th April.
The first two orders. APO 5 is against, my lord, orders dated
26 March and 8th April.
8th April.
And APO, which is the other APO?
7.
The APO 5 or APO 7, no? APO 5 of 2025.
May I have your lordship?
Yes.
I'm so grateful.
Is directed against orders dated March 26, 2025 and April 8, 2025 passed by the learned commercial judge. Rajarhat.
Commercial judge at Rajarhat.
Number 8.
My lord, 8, I am for the petitioner, my lord. On the last occasion,
Yes.
my lord, I am for the petitioner in this matter. Means on the last occasion, my lord directed to serve them a copy. So, my lord, we have served them the copy. This is the affidavit of service.
Affidavit of service. দাও তো দেখি affidavit-টা। Have you seen the affidavit of service?
My lord, it is delivered, my lord.
Yes, item delivered to who? To the sender.
Yes.
Who is the
My lord,
sender?
another address is there, my lord.
Yes, the next time addressee. No. Yes, 28th April বলছে addressee. 30th April বলছে sender. Oh. Yes, so what is the nature of the order you have challenged?
My lord, in this matter, I'm been led by Mr. Obhijit Bardhan, who is on his legs. My lord, kindly keep it.
Pass over, চলো। Affidavit-টা ফেরত দিয়ে দাও এখন।
My lord, he's there, my lord.
Mr. Bardhan, service, we are a little confused because 28th April track reports says that it's delivered to addressee.
Well, there are two addresses, Malad.
I see.
There are two addresses, Malad. Kindly see the Malad, the notice. It's at Shakespeare Sharoni and at Nachan Road, Kamalpur. So, Malad, one is in Durgapur, one is Shakespeare Sharoni, Malad. Now, Malad sees the track reports at page 4 and 5, Malad. There are two. So far as the first one is concerned, Malad, that has not been delivered.
Which is that one?
That's the Shakespeare Sharoni one. And the second one, my lord, sees item delivered, just sees to the left, my lord, Durgapur Steel Units West SO. So Durgapur has been, my lord, delivered.
Yes.
In fact, my lord, that is the precise case I run in my 711. Saying that the entire cause of action arises at Durgapur and not at Shakespeare.
Your 711 is pending.
Yes.
Before the Learned Trial Court. So what is your grievance against this order? Injunction?
Injunction, my lord. Basically an order for attachment for judgment in the garb of injunction.
Pure money claim?
Pure money claim.
Would you like to try to serve? কি করবি বল? Release তো হয়েছে।
You can extend the interim order and keeps the appeal for hearing. You will serve in the meantime and come back.
We have passed an interim order.
There.
Oh.
Interim order, my lord, is dated by 24th of April 2025. The interim order is, my lord, there till 8th, my lord. The matter was supposed to appear today.
I see. Please serve again.
Shakespeare
should only try hand service.
I'll try.
If from affidavit from the affidavit of service filed in court today, that it appears that the respondent has received notice of this appeal at its address in Durgapur. Stop. However, nobody represents the respondent. Stop. Paragraph. May 8 অব্দি তো stay করাই আছে।
Yes, but till May 8th, there's not a stay.
So paragraph, let fresh service be effected on the respondent and affidavit of service be filed on the next date. Stop the interim order of stay that is in operation shall continue till May 15 or until 2025 or until further order, whichever is earlier. List the matter on May 8.
Read for
Item 10.
Yes.
For the respondent, my lord. 37 appeal, my lord. Last occasion, I am told, my lord,
Oh,
state
Passover. In the second call, you know what's going to happen. Passover.
11.
that matter, my lord, Mr. Aniruddha Chatterjee, my lord.
Mr. Chatterjee is not here, my lord. If my learned friend clarifies what is instruction, if they
My lord,
want to,
may
my
I?
lord, go to my lord, fresh arbitration, my lord, then we will not argue. If not, my lord, then I'll convey to
My lord,
Mr.
I have
Chatterjee, my lord.
taken instructions, my lord. And my lord, my instructions are clear, my lord. I have certain points to argue, my lord, and I will show from the records, my lord, of the arbitrator, my lord, as well as my lord, from the orders passed, the minutes dictated by the arbitrator, by the 34 court, and also by one order where the section in an application under section 11, my lord, all they have disclosed, it's everything is in the paperwork, my lord. I would like to argue on this point, my lord, and my lord, the extent of section 3 of the Arbitration Act, my lord.
So basically, your client is not agreeable to Mr. Chatterjee's suggestion. That's it.
No, my lord, because
Fine.
I would
No
like to
problem.
argue on this point.
Today, Mr. Chatterjee is not there.
Not there, my lord. He is not in town itself.
I have no problems, my lord. I can wait.
Monday?
Monday is an original side day, my lord.
This is appellate. Tuesday?
Tuesday.
6th.
6th. Yes, 6th. 6th, I am here, my lord. 7th, I am not here. 7th and 8th, I am not here.
Read Read order dated April 29, 2025. Paragraph. Mr. Ghoshal, learned senior counsel representing the respondent, tells us
Mr. Chatterjee was on wheels, not really on legs.
One glance, my lord, from
A
Jalpaiguri
glance
circuit
and
bench.
a glance from Jalpaiguri, my lord.
Circuit bench.
We
don't
have
want
been
to see
able
it.
to, at least I and Mr. Bhattacharya, my lord.
He's
But
there.
now Mr. Chatterjee is really on wheels, my lord.
We don't see anybody in the car like that. No. One has to be in a chamber or in a library or whatever.
Trying to rush to the court, my lord.
Daku.
মঙ্গলবার হবে রে মঙ্গলবার deeply obliged, my lord.
Item 12.
This is my appeal. Lord, I am also appearing here. Lord, this is my appeal.
Your appeal, but is Mr. Chatterjee appearing?
Yes, also appearing amongst a battalion of others. May I start?
Yes.
12 number.
Or are you asking for accommodation?
I'm led by Mr. Jishnu Chaudhary. Till such time he comes, may I start?
No. You will continue then, Mr. Gupta. What happens, you see, after you argue for half an hour, Mr. Chaudhary will come and repeat the same points for another 15 minutes. This is the problem with relay. There's no other problem. But from our experience, we have seen he doesn't know what you're arguing. Mr. Chatterjee, are you still there? Me.
I'm here, my lord.
What are you asking for accommodation or what?
If possible, my lord, maybe tomorrow itself or whenever your lordship pleases. Or if they want to start, my lord, because we are for the respondents. Whatever your lordship desires, my lord, I have got.
May I humbly suggest one thing, subject to all's false? It's an appeal from a decree. May I just place the impugned decree once? Yes. My suit has been dismissed with undue haste, if I may use the word. And may I just place the impugned judgment?
Yes, we'll have to hear all parties.
Yes.
You may have a very strong case, but just because of that, we can't allow your appeal without hearing the others.
Absolutely.
Now, if Mr. Chatterjee is not here today and we refuse to hear anybody on virtually, I can't.
I bow.
That is what we are saying.
I leave it.
So then come back tomorrow, no problem. Or tomorrow will be a little uncertain because there are several broken benches tomorrow.
On Tuesday, my lord?
On Tuesday. Come back on Tuesday. Yes, come back on Tuesday.
So grateful, my lord. So grateful.
Daku, second call karo. Decree of?
It's a decree dismissing my suit for delivery pen cancellation.
Which court?
By the commercial court at Rajarat. This is with regard to one of the allotments under the chairman's discretionary quota, which was left out, for which, my lord, your lordships were hearing that your lordship sitting with Honorable Justice Rai Chattopadhyay had delivered the judgment upholding the cancellation of allotments. This is one of the deeds which we could not cancel because the deed of conveyance was executed. So this is that suit for delivery pen cancellation of that deed of conveyance.
Should I take it up?
Yes, my lord.
No, because I formed a particular view, you see.
No, my lord, this is nothing to do with that, because your lordship said that I am not deciding any issue with regard to Mr. Chatterjee's client's arguments. That
I said so.
Yes, and the suit would be decided on its merits.
Don't remember a thing. Absolutely.
Then your lordship, there's no problem.
Tuesday.
Great.
Pass over matter, item number 10.
Give your appearance.
But they will come.
If they come today, it will be restored. Otherwise, they'll have to file a restoration cost, etc., etc.
Also ask for an affidavit because I'll go and now apply for execution.
Very well.
I thought give your appearances for us, but
No.
I don't think.
Vijit, in the first call, nobody appeared for the appellants.
Mr. Anirban Rai will come running.
In the second
not
call,
today.
also nobody appears. Paragraph dismissed. Interim order, if any, stands vacated. Next.
All interim orders are vacated.
Yes.
Not commercial. Huh? Can I, my lord, then, my lord, the Registrar General, my lord, can encash the amount which is lying with them, with the fixed deposit he is.
Why don't you write to the Registrar General saying that there is no order today, no restraint order? If you face difficulty, come back. Within that time period, they would have filed a restoration application. What is the amount lying?
Very big amount.
Very big amount.
The commercial, my lord,
Then they'll come running today itself.
that takes some time, my lord. Monday, my lord, I expect.
এক নম্বরটাই নেই রিভিউ 153 দাও এই নন কমার্শিয়াল চেঞ্জ করে দাও
এটার মানে কি? As
non-commercial matter
assigned. As signed even. আসেনি?
item number 1
আগের দিনও আসেনি। হ্যাঁ? এটা কি হলো? অ্যাসাইন থেকে কি ডিসমিস হয় না নাকি? 2016 রিভিউ করো। দেখে নাও This is an assigned matter. Stop. It was called on for hearing. It was listed on পরশু দিন ছিল না? জিজ্ঞেস করো পরশু অন ডেটটা দাও। হ্যাঁ and was called on. Stop. Nobody appeared for the review applicant. Paragraph. Today also nobody appears for the review applicant. Stop. The RVW such and such is dismissed along with can আছে একটা দেখে নিও।
Number 4.
Yes, my lord. We have the financial, my lord, in arbitration matter.
For the respondent, Lordship, I am raising a point of maintainability. Raising a point of maintainability of this appeal. This is not against an award.
The award has been passed at page 104. I am sorry, at page 27. 104th order. Relevant, my lord, page 35.
You were the award holder.
No.
Yes.
They applied under section 34. Setting aside.
Appeal. File an appeal
Under
under
section
section 34. And there, my lord, they filed an application for stay with no objection, and the court granted as an interlocutory application.
Lordship, we have not filed any application for stay. We have filed an application for no objection because it's regarding our auto rickshaw.
Please,
It was exhaust.
let me exhaust. Don't be so hurried. Now, there, the award was 2,43,445, and they, my lord, make an application. If your lordship kindly find.
Have you paid the 53,580?
We have paid.
That you have paid?
Yes, 1,000 rupees
And what is the
52,000
award?
we have paid.
And what about the rest of the award?
The appeal is pending, Lordship. The appeal is pending.
Can't take
Your
away
Lordship
in
will
both
kindly
ways.
come to the order
Because-
under challenge.
Pending.
If my learned friend allows, we have filed an application only for no objection.
No objection, how it will be given? By this time, my lord, the vehicle was registered on 2010. By this time, this 15 years have passed. So this is not for no objection. They will get, if it is allowed in that case, they will have been given fresh number, fresh registration number, everything.
After 15 years, how will you renew your registration?
We
And
cannot
they
renew
want
unless and until and no objection. is
Forget
levied.
about no objection.
It will go into scrap, Lordship. I have explained it in my application.
Go into
15 years is
scrap.
the age
And it
of
has
the auto
been
rickshaw.
decided I am a owner.
I have
and
to go to
it will go
the
everything.
Lordship, as per my
Not pay.
instructions, as per my record,
He
I
will
have
not pay
paid
anything.
the entire amount.
He has not
And that is
appeared
appeal
even.
is before the learned
He appeared,
district judge.
never filed any
And
filed any
firstly, Lordship, this
counterclaim.
appeal is not maintainable because they are coming against an interlocutory order.
How
the interlocutory
how
order is
in
challenged
appeal court
under appeal.
decide an interlocutory matter?
Lordship will
Take my
kindly
lord, order 41 rule
under
5 speaks about to secure my amount.
under section 37 it cannot be
Unless the
challenged.
award is set aside, how you can without securing?
No, we are not
by piecemeal making an application and you will go on, carry on. That is my grievance. তোমরা কি কপি সার্ভিস করেছো? They appeared before the arbitrator, did not file any counterclaim. Again, there was a change of advocate, did not file anything, ultimately did not appear.
What provision you have preferred this appeal?
My lord,
Under section 37.
that is an appealable order. Section 37.
Yes, this is not an appealable order.
My lord, that is the problem is by this time.
The problem is that what can we do? It's a commercial court again. Commercial, na?
No,
No, it's a commercial. Na. It's a commercial.
It must be commercial.
It doesn't come within 37, sir.
It is revisable, my lord.
You maybe so you go for that. So do you want a rejection or you want to withdraw?
That is the withdrawn will be the best. We are giving opportunity to take back the certified copy.
That you take. Huh?
Grateful to your lordship.
Your Lord, देखो ना.
Next item, my learned. Next item, my learned friend would take an accommodation today.
What recommendation? You are for whom?
I want to respond in my lord.
I have not
On last
received the
occasion,
Wakalatnama as yet, my lord.
So what do you want? Not today, not this week.
he says he has not received the Wakalatnama.
Wakalatnama as yet,
Last occasion, when the matter was being heard by justice.
probably they are not willing to proceed, so that's why I'm just waiting for
Then
written
say
instruction.
something.
So, my lord,
Who is not willing to proceed?
the legal heirs of the respondent, the deceased respondent.
I'm for the
So
appellant.
that's why I want to.
So when will you come back? Tell us.
2 weeks, my lord, 2 weeks.
2 weeks.
Yes, my lord, 2 weeks. After 2 weeks.
Who are you?
Lordship, not in this matter.
You are assisting him?
No, your
then?
lordship. In another matter, item.
Hey. Lekho, learned advocate for the respondents. seeks 2 weeks time to obtain better instructions. Paragraph list this matter once again on করে দিয়ে দাও তারিখটা. চলো.
May I file my affidavit of service?
Affidavit of service filed in court today. We kept with the records.
Lordship, I tender my unconditional apology, Lordship. In item number 10, Mr. Shakushin was there. Lordship, I was not able to reach your Lordship.
You were for the state.
For the
Order
state.
Corona, then dismiss Corona.
Lordship.
Not today. 10, not today.
Much apologies, Your Lordship.
10.
Item number 10, commercial.
the state had indicated that they'll be seeking some time to, actually there's a books also.
So what do you suggest? Tell us.
Lordship, may it stand over for a day, Lordship, that in that event?
Not today.
Yes, Lordship, that.
হয়ে গেল?
Appellate side over. এটা কত? 49
Original side commercial bank, item number 1.
Lordship, I appear for the respondent in this.
Pass over.
Item number 2.
2 is my appeal, Lordship. Kindly take it up tomorrow.
Not today.
Lord, may I pray for next week, my lord, in that case?
Monday.
Very one. One.
Item number 3.
Item 3, my lord, I'm appearing for the appellant, my lord. The affidavit of service shows, my lord, the respondent has been served.
Where is the affidavit of service?
It is filed, my lord. I'm told that the possibly, my lord, the respondents have not received it yet.
Have not received?
Not received it.
Yeah, filed it. They just served them. But they never appeared in section 9.
So this is an appeal against an order, my lord, passed in a section 9 proceeding. There also, my lord, the respondents never used to appear, my lord. We suffered an order and we have come against that particular order before your lordship.
দেখি দাও। What's wrong with the order? Pure money claim.
Not money claim, my lord, it's an unimpeachable claim. It's an admitted claim.
Maybe.
Lord,
obtain an award, execute it. Who stops
Lord,
you?
section 9, my lord, I'm entitled to an, my lord, interim protection under section.
Who says? Under which law that you are, as a matter of right, entitled to?
Lord, I'll satisfy. My lord, will kindly take.
What will you satisfy? As a matter of right, the court has to pass an order.
Now, my lord, the Honorable Supreme Court has stated in arbitration cases, my lord, in section 9 cases, court may not be bound by the technicalities of Order 38, Rule 5. What has to be looked into is whether it's the nature of the claim, whether it is unimpeachable in nature. If it is admitted, then in the interest of the parties, it will be secured in a separate amount, separate earmarked account, so that my interest is not, my lord, affected, my lord. Previous, my lord, views were that the principles of Order 38, Rule 5 was applicable, my lord. But now, my lord, with the SR judgment, followed by, my lord, I have judgments of the Honorable Division Bench of the Bombay High Court, my lord, with similar view. My lord, it's a loan agreement.
Your loan agreement?
Your loan agreement.
No hypothecation,
No
nothing.
hypothecation, my lord, it's an unsecured loan.
Show us what you want to show.
But may I just hand over the copy of this Supreme Court judgment?
Which paragraph?
But paragraph 48 onwards. In fact, my lord, I'll
no, but did you say that the service is not complete? Not complete.
Not complete.
No. Then why are we wasting time?
And may I pray that this matter be listed next week, my lord. In the meantime, we'll ensure that the service is complete.
Learned advocate for the appellant says that service is not complete. Stop as requested, comma, let this matter be listed again on
Tuesday, my lord.
Tuesday date the other. Stop. On that day, affidavit of service should be filed in court.
Grateful. Pass over matter item number 1.
Chief, I appear for the respondent defendant.
Oh, sorry. ये करो usual है appearance नहीं ना usual तो तुम्ही जानो ना बोले लिखे ना in the first call nobody appeared for the appellant's call. Stop. In the second call also nobody appears. Paragraph APDT such and such is dismissed for default along with along with the connected application. Stop. Interim order if any stands vacated. Appeal from decree.
Appeal from decree, the
Money decree.
No, Your Lordship. They had obtained an order of injunction. So leave under section 12 where they had obtained, that has been dispensed with. That was revoked by the learned court, and thereafter the suit has been dismissed in effect.
Item number 4.
Grateful.
चलो কি করছো চলো
Item number 4. Item number 5. 5 and 6.
Lordship, I am appearing on behalf of the respondent.
Very well.
Short passover may be.
Yes, that's what we are doing.
Item number 7.
My lord, I appear for the respondent.
Yes, Passover.
Item number 8.
For the respondent, my lord. Appearing.
Yes, 8.
Yes, sir. Yes.
You're in which matter, sir?
Number 8, Your
8.
Lordship.
For whom?
For appellant, I'm led by Mr. Jointo Mitro, sir.
Mr. Mitra is appearing in the matter.
Right, a short passover, Your Lordship.
Passover.
Item number 9 and 10.
In this matter, Mr. Shishona Bandyopadhyay appearing. In this matter, we prefer appeal against the section 34. My lord, kindly pass over. My lord, I'm led by Mr. Shishona Bandyopadhyay, my lord.
For whom?
For whom? For appellant, my lord.
Passover.
Obliged.
My lord, there are two, my lord, cross appeals. My lord, section 34, my lord, the award is in my favor. My lord, partially modified or my lord, partially set aside, may I use the expression? Because now, my lord, with the recent judgment of the Supreme Court, that has, my lord, come under scanner.
You can't modify. No.
It says you can modify, but you can't modify. So, my lord,
You can modify, but you
can't modify.
That's right.
Well, yesterday evening when I was reading the judgment, I was not totally confused. It says you can modify post-award interest. Says you can modify in terms of section 34(4) by sending it back to the arbitrator. But otherwise you can modify, but you shouldn't modify.
Anyway, what should we
my
do?
lord, in this matter, my lord, there is an award in my favor. Partially set aside by, my lord, the learned single judge. But against that, my lord, two appeals have been preferred. One by my client, my lord, against the partial setting aside. And, my lord, another by my lord, my learned friends on the other side, saying that, my lord, ultimately they should have been, my lord, given more, my lord, a greater part should have been set aside. So, my lord, these two have to be heard together.
Yes. When? Mr. Shishon Banerjee is appearing?
He is, my lord, assisting me. But I
Oh,
don't
he is
find the other
assisting
side.
you.
Yes.
Other side is not there then.
No. So, my lord, kindly fix any date, my lord, next.
You are for Keshoram or Mintek?
I am for Mintek.
Please tell us any date that suits you. Consult your diary.
Apart from 7th and 8th of the next month, my lord, any date that is convenient for your lordships.
Either 6th or 13th.
13th is fine. You can do it on the 13th. I'll inform the other sides.
Keshoram Industries Limited. Keshoram Industries Limited Cement Division is not represented. Paragraph as suggested by Mr. Shaha, learned senior counsel representing Mintec, M-I-N-T-E-C, Global Private Limited, let this matter be listed again on May 13, 2025. Stop. Learned advocate on record for Mintake is requested to communicate this order to learned advocate on record for Keshoram.
Yes, my lord. Great.
No, item number 11. Passover matter, item number 4.
I appear for the appellant, but I'm led by Mr. Jayanto Mitra, my lord. He has not reached the court yet, my lord. I'm informed that
He has
he's on
not
his
reached the court.
my lord, he's on his way to the courtroom, my lord.
Not today.
Very well. Grateful.
Item number 5 and 6.
I appear on behalf of the respondent. This is that matter with relating to the assignment incorporation by reference of one contract into another. Mr. Anirban Rai was
And my lord had given a judgment to consider, my lord. My lord, my lordship,
Right.
yes, Justice Rai has given. My lord, both of our senior are engaged in court number 6, my lord. We have requested for that.
both of them are opposing each other
Yes,
also in
in-
that matter as well.
Not today.
Grateful.
Item number 7.
My lord, my lord, appear for the state of his, my lord, for the appellants, my
For the
lord.
respondent.
My lord, in this matter, my lord, the learned advocate general, my lord, is appearing for the state, my lord. The appeal, my lord, from an order under section 9. My lord, the point involved is, my lord, with regard to arbitrability, my lord, I'm sorry, my lord, arbitrability, my lord, of the disputes, my lord. My lord, the learned advocate general has requested, my lord, if it could be taken up, my lord, immediately after the vacation, my lord, if it comes as your lordship.
Yes. You're for whom?
Lordship,
I for the respondent, my lord.
My lord, they are enjoying the interim order, my lord. They are enjoying the interim order. We are in fact suffering.
Section 9, section 37, whatever, my lord.
Yes, they have appealed against a section 9.
My lord.
Section 9 order is in your favor.
My lord.
That order, there is no stay.
No, my lord.
Then, no problem.
But I have no. Whatever. My lord.
Learned advocate for the appellant oblique state capital, requests this matter to be taken up immediately after the summer vacations. Paragraph lists this matter once again on June 11. 11 June?
Very, very, very deep relation. Very deep relation.
11 June 11, 2025.
Grateful, my lord.
Grateful. Grateful.
Item number 8.
For the respondents.
What's my application? I'm led by Mr. Jayanto Mitra. He's on the way. Short password.
There's nothing else left.
You can start. Start for
Nothing else is left. This is the last matter in the second call.
Well, they are they are enjoying an order of stay, my lord.
Yes.
Of the award.
No.
My
Appeal
lord,
against what?
nutshell. My lord, I will apprise my lord with the nutshell of the matter. It's an extraction of coal bed methane gas. The award holder, they have got the license to extract coal bed methane gas. Now, the petitioner here in my lord, they are the manufacturer of TMT bars that require the furnace to be with that coal bed methane gas, and substantial negotiations were done from both sides, and my lord, thereafter one agreement was executed by and between the parties, where the name of the agreement is GSPA, Gas Sales Purchase Agreement, my lord, which contains several clauses. Mostly the clause which is a dispute in
the award was in whose favor?
Award in my favor, my lord.
You were the claimant.
I'm the claimant, my lord. After that, in section 34, my lord.
Both sides filed section 34.
No, my lord, we did not. We did not.
We filed
If
34. We
the
filed.
appellant before your lordship filed a section 34. Section 34 also they have lost.
Oh, you filed execution.
We filed
Exactly.
it. And my execution has been stayed, my lord, because
My lord,
there's
we have
no-
already deposited 15 crore
My lord,
rupees.
but
That
that's-
matter went
my lord,
to
the
Apex Court, and
award is of
there was
100
an
crores,
order.
my lord.
Might be
My lord,
there's an
15
order
crores
of the Apex Court, my lord.
My lord, be
The
that as it
34
may-
we lost. We went to.
Be that as it may, now the appeal has to be heard out, my lord.
No, we are always ready for that.
Appeal has to be heard out.
Mr. Mitra, as you know that he is
Appeal, we'll hear out the appeal.
Yes, my lord. We are.
When? Tell us.
My lord, tomorrow, my lord. Or tomorrow.
Next week.
Well, then Monday in that case, my lord.
Monday.
Monday.
Monday. All papers are before us?
Yes, yes, my lord.
Annexed to the stay petition?
My lord.
Notes have also had.
My lord.
My lord. My lord.
I've just started.
Mr. Muthu, your junior suggested and also your junior and Mr. Mukherjee.
Junior.
Appeal has to be heard out. On Monday, we'll hear out the appeal if it suits you.
Yes, it suits me fine, man. And if it suits your lordships, it will suit me. Definitely.
Dekho, this appeal is directed against a judgment and order dated September 9, 2024, passed by a learned judge of this court, whereby the appellant's application for setting aside of an arbitral award was dismissed. Stop. Paragraph. We are told that all papers that were available before the learned single judge have been annexed to the stay petition. Stop. Treating the stay petition as an
Paper book has also been
paper book filed.
Yes, it's paper filed.
Filed.
Paper book
Yes.
has also been
It is ready for hearing.
Ready for hearing.
We are told that
Paper book
we are told
also, convenience volume has also been filed.
paragraph. Paper books have been filed. Stop. We propose to hear out the appeal.
Lordship.
Paragraph lists the matter under the same heading on Monday. Monday date the
Well, this will appear at the top.
Very well.
No, because well, I have got the item number 4 also. I am ready in that matter also. But I think, well, this matter, if it comes up, then this will be heard first. I don't mind that.
We would much rather prefer this is heard out.
Very well.
Actually, you will
On Monday as the first item under the heading appeals from orders.
Lordship.
Grateful. Same heading as the first item under the heading.
Monday first matter. Monday this be the item
Hey.
of first matter. তুমি আছো
You are opposing Mr. Mintru. How dare you?
Only for a just cause. Only for a just cause.
So he egged me on. He said that your matter will be called down, you have it done as soon as possible. And
Sir,
now,
আসছিল আমি, sir.
now আমি আসছিলাম.
Via একটা code.
I am much slower than you.
Via একটা code.
You just
বলেছি সোমবার দিন ওপর দিকে থাকবে.
একদম number 1.
I'm grateful.
Lordship.
You can, if it comments to you, you can keep your oral submission brief and file written notes.
Yes. Malad, we have already filed Malad or written notes.
Oh, written notes ache?
But Malad, I am sure when your lordship looks into the written notes, your lordship would much rather prefer that let the oral submissions be heard.
No. That Malad, Malad, I stand by my notes.
No. You better make your
Malad,
oral
we have
submissions.
One stage, Malad, we have gone through it. Malad, second stage, Malad, I stand by my notes. Malad, it's not a.
We are talking about written notes, not currency notes.
That also.
Very well.
Only Malad, if we succeed, then only Malad currency notes will come Malad from that side.
All right.
As damages.
আমি ওই একটা করতে হবে কোনটা সেক্রেটারি ওটা বলবেন
Lordship, we had item number 1, appeal unique entrepreneurs versus Really, which was dismissed.
Unique entrepreneurs.
Unique entrepreneurs.
Yes.
The counsel in the matter was Sir Subhasis Sengupta and Bhavesh Ganodia. Both of them are at the moment held before Honorable
Not very
Delhi.
well, but how are we supposed to know that, sir?
I humbly request.
You are for the appellant.
I am for the appellant.
Corona order to Corona, not today.
Much obliged, Your Lordship.
Non-commercial for argument, item number 1, for judgment, item number 1.
I'm sorry, my lord. One matter of mine, I think item number 4. Well, that has been made not today. That means will it be taken up tomorrow?
Highly unlikely. It's tomorrow, 12:30, there's another bench. From 2 o'clock, this bench is not available.
Even, my lord, may I submit
Monday.
let this matter, that matter also appear on Monday after the matter in which Mr. Barron appeared.
Oh, I see. He says it's highly likely that it will be heard on not kalke. Kalke hoye jabe. Friday, original site commercial is first tomorrow.
Oh,
So you want to do it tomorrow or?
If that starts, then that will continue. Then the other
Then
matter.
শোনো এইটা হচ্ছে যেটা বললাম টপে আসবে তারপরে মানডে.
Yes, very grateful to your lordship.
Kindly ask your junior to your
The other side is present.
ঠিক আছে, তাতে কোনো অসুবিধা নেই তো? Grateful.
Non-commercial matter item number 1.
I appear for the appellant.
Judgment.
And I'm for the
বিয়ে কর, হ্যাঁ সই কর আগে। ও তুই ওই যে যেটা বলছিলিস।
We have considered it and we have dismissed your application for condonation of delay. And by reason thereof, the appeal also stands dismissed.
That's.
We have given our reasons to be on.
My lord, oblige.
Item number 2.
সই করেছি না সার্ভার করো না কারণ ইনিশিয়াল হয়নি সাহেব ইনিশিয়াল করে পাঠিয়ে দেবে
Item number 2.
Rajda Industries, na? Rajda Industries.
Yes, Rajda.
Matter is pending before the Honorable Supreme Court. The next date is on 28th of
It has gone
July.
It has gone up from an interim order of the appeal court.
No, it was a lordship. Initially, we filed an appeal. There was a subsequent.
You are for
order.
whom?
I'm for the plaintiff, lordship. Appellant. Appellant, lordship. So already an appeal was pending, lordship, against the challenging the election. In the meantime, lordship, there was a Section 8 application pending in the suit, lordship, which has been allowed. Against that, lordship, the appeal is pending. So if the Supreme Court dismisses set aside the order.
Section 8 allow mane appeal nahi.
So if that is set aside, lordship,
So
then
your SLP is pending.
Lordship, my SLP is for the timing, let it go out of list so that it can be.
Learned advocate for the appellant says that the appellant/plaintiff's suit says that the defendant's application under Section 8 of the Arbitration and Conciliation Act was allowed by the learned trial court. Which court?
His Lordship, the Honorable Justice Nadira Patria, Lordship.
By the learned single judge. Trial court corona. Stop. Single judge. Stop. The plaintiff's special leave petition against such order is pending before the Honorable Supreme Court. Stop. He suggests that this order, this matter should go out of list with liberty to mention.
Lordship.
Paragraph, let the matter go out of list with liberty to mention.
Item number 3.
Perhaps, Your Lordship, this matter, item number 3, Lordship, was especially assigned to a Lordship. I have, Lordship, forgive me, only I have one copy.
Especially assigned to this bench? No.
Lordship, this was the last order. Perhaps, Lordship, will.
আমাদের লিস্টে এলো কি করে? হ্যাঁ, learned advocate, you are the
My
appellant.
lord, no, my lord, my lord. This is my application, my lord. I am appearing for respondent number one, and respondent number one has file application, my lord. And as far as
Just 1 second, sir, 1 second. LNJ International. Number 3 is Dankuni.
Dankuni is still limited, my lord.
Hmm?
That is another application, my lord.
This... LNJ. What order have you given us?
No, no. My lord, may I submit?
1 second, 1 second. দেখাও কি দেখছো? ভুলভাল অর্ডার দিয়েছে।
My lord, may I make humble submission, my lord?
Where's your other side?
He is one of the other side, my lord, and one is my lord Sri Muni LMJ International Limited, and
Item number 3, where is LMJ?
no, my lord, he is I think second respondent. LMJ International Limited is the respondent number 2, my lord.
Yeah, and others.
So it's a Dankuni Steel versus Tharat Chatterjee.
Yes.
So Dankuni Steel is myself, Lordship, the appellant here.
Yes.
This is an appeal where, Lordship, the sale was conducted and the properties were supposed to be sold by the special officer, Lordship, where we filed an application, Lordship.
GA4 is whose application? Very confused, Shavai.
GA4 is, my lord, my application filed by the respondent number 1.
For what?
My lord, the application was filed for direction upon a special officer to expedite the sale, my lord.
You served all the parties. Where's the affidavit of service?
My lord, direction for affidavit is given, but today, my lord, I am praying for accommodation, my lord. For the reason, my lord.
Well, we don't want to know the reason.
My lord, kindly give me 2 weeks time, my lord.
Because
I have to make.
On the request made by learned advocate for the applicant oblique respondent number 1, comma, let this matter stand adjourned for 2 weeks.
Grateful, my lord.
But he's not for appellant, Lordship. The
applicant.
Lordship.
Applicant.
Item number 4.
চলো পাস ওভার করো কি করো
Item number 5.
ও সরি এই এসো একটা বলে দিচ্ছি this is an old matter of 2014 stop this was listed এটা এসেছিল তো এই গতকাল ওয়ার্নিং লিস্টে ছিল this appeared in the warning list of কালকের ডেটটা দাও গতকালের ডেট paragraph when the matter is called on nobody appears stop APO such and such is dismissed. Stop. Interim order, if any, stands vacated. 29 তাহলে হ্যাঁ হচ্ছে warning list of 20 April 29.
Item number 5.
Same order খালি ইয়ারটা পাল্টাবে দেখে নিও 2014.
My lord, I'm on behalf of the petitioner. Kindly give a pass over.
Oh.
Item number 5.
You have item number?
5.
5.
Praying for passover, my lord. I'm on behalf of
You're for the appellant? Passover?
Thank you.
Item number 6.
Same order, year 2015.
Item number 7,
Same order.
item number 8,
Same.
item number 9,
Lordship, I appear for the petitioner, Lordship, in this matter, newly appointed, Lordship. Kindly 2 weeks time to go through the file, Lordship, and file my Vakalatnama also, Lordship.
On the prayer made on behalf of the appellant, let this matter stand adjourned for 2 weeks and be listed again on 15, May 15.
Grateful, Lordship.
item number 10,
Well, I appear for the appellant. Well, in this matter, Mr. Dutt is on the other side. He has a analogous appeal. It was being heard. It's come in the warning list, but anytime your lordship fixes it.
Give the number.
Mine is 480. Ours is 489. There's
When-
486 of the same.
When do you want to tell us?
On the reopening.
Next, after reopening.
After 1 week afterwards.
On the request made by learned senior advocates, आपने case किया वो था. Senior advocates for the parties, let this matter be listed again on June 12. Stop. On that date, APO
486 and 487. 486 and 489. 489 is appearing.
So 486, APO 486 of
2015.
2015 will be listed immediately after this matter.
14th is the bar dinner. But not that it will affect the morning.
item number 11,
Same order, ইয়েরটা দেখবে আর শোনো বাবা যেখানে দেখবে জিএ গুলো আছে dismissed along with জিএ যা আছে সব দিয়ে দেবে.
item number 12,
Same order.
item number 13,
Same.
item number 14,
Same.
item number 15,
Same.
item number 16,
Lordship, item number 16, I'm appearing on behalf of the appellant. Your Lordship, is an appeal arising out of your Lordship's order passed by Lordship Justice Banerjee.
My order?
Yes, so it's an
Which one? 15, 16?
Lordship's an appeal arising.
Deepthi Chatterjee? Released. Dismiss করতে পারবো না।
I appear on
না
behalf
না
of
কেন go out কিসে রিলিজ হবে আমাদের লিস্ট থেকে।
I am appealing appellant, your Lordship. I am appearing on behalf of appellant, your Lordship.
This appeal is directed against, we are told that this appeal is directed against a judgment and order delivered by one of us. Bracket আমার নামটা দিয়ে দাও। Paragraph, accordingly, this matter stands released from our list. Stop. Let the matter be placed before the Honorable the Chief Justice for appropriate direction.
This will be judgment and decree, your Lordship.
Judgment and decree করো order না করে। What kind of a suit it was?
Testamentary.
Oh, I see.
item number 17,
Your Lordship, I appear on behalf.
Yes, you are for?
Plaintiff Rajiv Chopra. I'm led by Mr. Nirmal. He's on.
Rajiv Chopra or Maheshwari?
Rajiv Maheshwari.
Your client will not even pay your fees. Forgetting his name. What do you want?
He is actually since been deceased, so we have to file a substitution
Rajiv
application.
Maheshwari has passed away.
Yeah, he has passed away.
Learned advocate for the appellants, says that the appellant number 1 has passed away. Stop. On his request, let this matter stand adjourned for 2 weeks to enable him to take appropriate steps in the matter.
Much pleasure.
item number 18,
Same order. ইয়ারটা খেয়াল করে পাল্টে দিও ইয়ারগুলো।
pass on matter item number 5,
Not today করে রেখে দাও তো। আর ইয়ে কৌশিক
9.
New application item number 19.
Lordships,
My lord is unwilling to take up this matter. Let this matter stand released from our list on the personal ground of one of us. Shaiben Nam diye dao. Paragraph, let this matter be placed before the Honorable the Chief Justice for appropriate direction.
Lord has released the matter, my lord.
Which one?
Item number 19, my lord.
Yes.
Sorry, my lord.
Why do you look so shocked?
Lord, I just came running, my lord. I didn't know the matter had been taken. I was just asking if this is our matter that's going on, my lord. I'm sorry, my lord. I should have.
Item number 20,
I'm grateful.
21.
But I do appear for the plaintiff appellant. Now, Mr. Chaudhary, learned senior advocate, has been briefed in the matter.
Mr. Ohin Chaudhary?
Mr. Shoboshachi Chaudhary
Acha.
has been briefed in the matter to argue the
Mr. Mukherjee is appearing for the respondent.
respondent defendant. Mr. Chaudhary is busy in court number 41. He has asked me to just pray for an not today because this matter will continue for the entire day. Just praying for a not.
Not today.
But then can
Monday.
have a Monday?
A Monday, no? Tuesday, then Tuesday.
Tuesday. You want some other day? Wednesday?
Tuesday is auspicious.
Tuesday is okay.
Item number 22.
For the respondent, madam.
Also opposing the appeal, my lord.
Ure Baba.
Well, this appeal, Mr. Chaudhary is here.
You for the appellant. Proceed if you want to.
Lord, we do it on the next day, my lord.
Yes, we don't mind.
When I tell your lordship,
We are in no rush.
Mr. Banerjee and I both have fixed matters at 3 o'clock, which is why just 1 day's accommodation.
There is one point, my lord. This is an appeal from refusal to pass ad interim order, my lord, where direction for only issue of notice is given, and the court has given direction for filing of affidavits, and matters to be decided thereafter. One. Number two, second point is this suit is also not tenable from a non-maintainable suit, a non-appealable order. So, my lord, we have a preliminary point on this maintainability of appeal also.
Sir, but I want to start.
You want to start?
Yes.
Mr. Banerjee is there.
Yes, yes, but on the next day, my lord. I just spoke to.
What's your objection? You want to start?
Police. 1 day's accommodation. Today, my lord, Tuesday, my lord, we'll do it.
Tuesday.
Sure, my lord, we will do it.
Tuesday আমি নেই।
Monday, except Monday, I'm not.
Tuesday থেকে আমি
Oh, তাহলে Monday, Monday. Oh God. আজকে হলো
We can
আমি কালকে নেই।
we can sit on Saturday.
You do it.
তাহলে আজকে করবে তুমি? আজকে করে করতে পারবে না।
Yes, do it.
Wednesday.
Well, I think it's up to me. I'm not there till the 13th, so I won't be able to.
Oh, you're not there till the 13th?
Yes. Monday I'm there, but I'm not there after that.
But Monday Mr. Mitro is not
Mr.
there.
Mitro is not there.
আমাদের বল আমরা শুরু করি না তুমি বলো মানডে তারপরে স্যার বলবে
No, this shuru kuri business will not do. If you start, you have to finish.
Then since our appeal and I'm naked.
না স্যার তুমি যেদিন থাকবে
Then 14th or 15th or 16th.
14th. On the request made by learned senior advocate appearing for the appellant, let this matter stand adjourned and be listed.
My prayer is for it to be taken up on Monday. Because otherwise, I don't want them to come and make that submission saying that you took time and therefore it got adjourned till.
So what?
What will turn on it?
No, then tell
I
you
made
do
the
it.
submission.
They'll take
What
the
will
point.
turn on it?
Take the point. তো তুই করে দে তুই কালকে কর পরশু মানে কালকে করবি তাহলে kindly keep it মানে Mr. Chaudhary is there he is there মানে he'll do it then
Not today.
well, I don't
We have no problem with 14th.
no মানে I don't want মানে but because it's an ad interim order we have come up against an ad interim order
No,
so মানে
we have to record some reason why we are adjourning
Yes.
for 2 weeks.
so they'll then Malad cite in and say they only took time there's no urgency this is the usual Malad which will submission will be made you will say I have taken time that's why there's no urgency so I don't want it to Malad my clients Malad to suffer because of Malad that my non-availability
Anyway, there are holidays. It's a broken week. 9, 10th, 11th.
Yes.
12th are holidays. So if you both agree, we can say by agreement.
I have no difficulty.
both agree then
Except Monday any day, man.
তাহলে দেখো ওইটা করে দাও হ্যাঁ Today there is not sufficient time to hear out this matter. Paragraph as jointly suggested by learned counsel for the parties, comma, let this matter be listed again on May 14th.
I'm so grateful ভরসা নেই তুমি ওই পয়েন্টটাই নেবে আগে ভরসা নেই তোমার হ্যাঁ নিশ্চয়ই গোত্র far more competent than I am
Item number 23.
আমি কোর্টকে
Lord, I appear for the applicant in this matter. Lord, this is an application seeking restoration of the appeal of an appeal, my Lord, under the Arbitration Act 1940.
When was it dismissed?
My Lord, this was dismissed on 23rd April 1998. But my Lord, there is some difficulty, my Lord. There is some confusion. My Lord, there were two numbers, APOT number 388 of 1998 and APO number 343 of 1998. My Lord, apparently, this was dismissed in 1998, the APOT number. However, the APO number survived. Lord, in this matter, an order was passed. Lord,
তোমার যখন প্রথম ফাইল হয় তখন এপিওটি tendon number.
Lord, if my Lord may kindly take up the order passed by this honorable court on 17th February. Lord, if my Lord may kindly take up page 64. My Lord, this will bring some clarity, my Lord. Page 64, order dated 17th February 2025.
এই রিপোর্ট ফাইল করতে বলেছিল এসছে কিছু রিপোর্ট নেই
My Lord, may kindly take up the next order, my Lord.
টাইম এলো কি হ্যাঁ এই অর্ডারের পর ফার্স্ট টাইম এলো তোর কিছু রেজিস্টার হ্যাঁ
রিপোর্ট এসছে না রিপোর্ট এসছে রিপোর্ট হ্যাঁ রিপোর্ট তো আগে থেকেই এসছে
সেই ওই ফাইল কোথায় পাবো আনো
অ্যাকচুয়ালি এপিওটি তে আমরা সবকিছু জমা করে
কত শুধু দিন বলে
আন্ডার দ্য বিলিভ এপিওটি সার্ভাইভ করছে
মানডে total confusion, come back on Monday. We have to get some more files to see if the registrar has filed a report which was called for by the coordinate bench.
My Lord, perhaps a report was filed because a subsequent order was passed in this matter on 4th March, my Lord, which is at page 66.
March this year?
Yes, my Lord. My Lord, by this order, we were granted leave to file the instant application seeking restoration of appeal.
সেই রিপোর্ট কোথায় রিপোর্ট তো আমাদের দেখতে হবে একবার
My Lord, at page 66 of my petition.
Come back on Monday.
Grateful, my Lord. Tender করে দিন।
Item number 24 to 28.
I appear for the respondent. This matter is under settlement. Hopefully by 19th of May, we'll have the terms ready.
Oh,
I'm led by Mr. Mithru.
in the goods of.
Yes.
Well, I have not held so many conferences in settling a matter. Well, I would have got ready in half the number of conferences I have held.
So shall we post it on the 21st of May?
21st of May, yeah. বলছে হয়ে যাবে? I don't believe you. 21st
The
of
appeal is from a order refusing appointment of administrator pendant. So we succeeded in the trial court. They want.
We are for the respondent.
Learned advocates for the parties say that this matter is in the process of being settled. Stop. Paragraph as suggested, comma, let this matter be listed again on May 21, 2025. Under the heading to be mentioned or what? Or under the same heading?
হয়ে যাবে না আমি I don't trust him. ও বলছে হয়ে যাবে no my lord, let it be the hearing. I am 100% sure it will not be done.
Under the same heading.
Mr. Mukherjee was SN Mukherjee is on the other side. He has come to my house to hold conference for settling. I have gone to his house for the purpose of settling. My lord, so many apart from my lord good food, really my lord, nothing transpired.
That is why it will never end.
Well, kindly keep it on the 21st and let it retain its position.
21st. Yes.
So let us try it.
Item 29.
Lord, I am for the respondent. Lord, in
Lord,
this
I am for
matter.
the appellant, my lord.
কেন বলতো? এই হ্যাঁ?
So, how are you?
Yes, 29.
Madam, I am for the appellant, my lord.
I'm for the respondent.
Madam, she can short pass on late by Miss Adho, my lord. It's an appeal.
It's an appeal. Yes, we can see it is an appeal, Mr. Paul.
Man,
Pass
my lord,
over.
challenge. Okay, my lord, pass.
Item number 30.
Lord, I do appear for the appellant defendant. Now, two of the parties, respondents, have expired during the pendency of the appeal. We have carried out substitution before the learned trial court below. Now, only, my lord, their names are required to be incorporated in the cause title of the present appeal. My lord, we kindly grant a leave to my advocate on record. My advocate on record will carry out the amendment in the cause title of the appeal.
You have to file a substitution application here also. Just because in the trial court records it has been carried out, that doesn't mean.
Substitution is subject to correction. Substitution has been carried out in the suit, in the
Maybe.
body of the plain.
Maybe.
But in the cause title of the appeal, and if either a
No,
leave
Mr. Dotto, no. That is not the rule. You will have to file a substitution application in the appeal.
we will do, as your lordship so desires, we will do.
You are defendant numbers?
I am the appellant.
Defendant numbers?
1A.
There are two appellants.
Two appellants. Defendant 2B and 2C.
The appellants oblique defendants 2B and 2C. 2 বোধহয় ব্র্যাকেটে ছোট b হবে নাকি দেখে নিও
আমার বি দাঁড়িয়ে থাকলে আমি কি করে বলবো
say that two respondents in this appeal have passed away. Paragraph as requested by learned advocate for the appellants, comma, let this matter stand adjourned for 2 weeks to enable the appellants to take appropriate steps in the matter.
application.
Item number 31.
31, my lord, I am for the appellant petitioner.
But I am for the response.
Well, there was a condonation of delay, my lord, of 577 days because, my lord, this is an order, my lord, which transferred the winding up petition. My lord, the companies, my lord, are family companies. In the arbitration in respect of, my lord, both companies, my lord, the winding up petition, my lord, was adjourned from time to time. And then, my lord, all of a sudden, my lord, came up one day and it was transferred automatically without any application. So motu rather, my lord, not automatically. My lord, we came to know, my lord, when the matter, my lord, went to the NCLT. So, my lord, thereafter, my lord, we preferred an
Who's
appeal.
binding a petition was it?
My lord, my learned
My-
friends.
my-
I am for the company. I am for the company.
Petitioning
Lord,
created.
so, my lord, I preferred an appeal. And because, my lord, I came to know later, my lord, quite naturally, my lord, there's a delay of 577 days. My lord, I came to know, my lord, in August 2024. Thereafter, my lord, I also took another 2 months, my lord, to file, my lord, the application here. My learned friend was given an opportunity, my lord, to file an affidavit. They have, my lord, not, they have opposed only, my lord, that gap period after I came to know. They said, after you come to know, then also you have taken time. That is really, my lord, the objection. Lord, I was respectfully, my lord, praying, my lord, if, my lord, the delay could be condoned. And, my lord, the matter heard, my lord, on the issue whether, my lord, it can be transferred suo motu or not, my lord, without any application. And particularly in this circumstance.
You know, Mr. Chakravarti, that we are very, very lenient regarding
That
condonation.
I am beneficiary of that leading. But my lord, this is a case, my lord. My lord, would kindly allow me. This is a
Yes,
case
we'll allow you to submit on merits.
on 2 minutes. My lord, thereafter, my lord, for 2 minutes. My lord, this is a case filed on 5th August 2024. Till date, there is no certified copy. Leave was obtained at the time when the matter was filed. My lord, according to them, my lord, their best case is last week of April or the first week of May, they have come to know. They appear before the NCLT and they say they will file their reply. They do not mention they are taking steps. They themselves say, we did not appear, my lord. First day we did not appear. My lord would see the order. They themselves appeared and say, I will file a reply. Thereafter, another day, matter was taken up. Thereafter, this matter was filed. My lord, from May to August, not a single date, not a single date. My lord, not a single date has been mentioned.
Not a single day.
But as to what has happened, what steps they have taken. They say in the last week of April or in the first week of May, they have come to know. Kindly see the pleadings. If this pleadings, my lord, with this pleadings, my lord allows, I'll not come in the way. But kindly see the pleadings. My lord has also.
Do remember that someday you will come with a condonation. And then if we ask you to explain every hour's delay.
My lord, I'm not asking for every hour's delay. I'll show 3 paragraphs. Thereafter, I'll leave it to my lord. My lord would kindly come to page 13. Page 13 of the petition.
এই হচ্ছে অর্ডার কি অর্ডারটা কোথায় নেই অর্ডারটা দেখেছিস
Page 13, paragraph H.
কত করবে
সেটেল করে দিতে পারতে দাদা সেটেল করা উচিত ছিল করছে না এইচ my lord would find
বা ছেলের মধ্যে ভাই
page 13 paragraph H. It was only in late April, early May 2024, the petitioner received a summons from the National Company Law Tribunal, Kolkata bench, intimating that so-and-so was scheduled to be listed on 8th May 2024. Immediately upon making inquiries with the advocate on record, who in turn checked so-and-so, my lord, thereafter, J. my lord, he appeared, page 55. My lord would find they had appeared before NCLT on 8th May 2024.
KLM টা পুরো দাও না KLMN
55 minute learned counsel Mr. Mitra appears for the company, submits that after the petition be made IBC compliance, reply be filed within a period of 2 weeks. So they submitted, they will file a reply.
Debtor.
Yes, my lord. Is one of the company, my lord.
Yes.
And Surya is the petitioning creditor.
Both, my lord, fight between the two brothers.
But they, Mr. The learned counsel for the corporate data appeared and said that they will file their reply. Now, my lord, would find page 15 that there was an intervening summer vacation. Thereafter, there was they were advised to file an appeal. They had conference. And this is the explanation. In paragraph 40, they say they have applied for the certified copy, which is not on record.
Certified copy still not available.
Well, not filed.
6 January 2023 order.
Well, not filed till date. But whether they have at all applied or not, this is a question mark.
You applied in May, so where is the certified copy? Where is the instructor? Without Kota. Bishop Kota. Lord, I'll find out, my lord, whether it's applied in May. But only thing, my lord, I can point out, my lord, is if my lord looks at pages 34 and 35, this matters, my lord, were getting adjourned because on the ground of, my lord, reconciliation between the two brothers and father. And not only that, my lord, there's an order, my lord, by the learned arbitrator with regard to this matter. 34, 35, and then my lord, 46, my lord, is with regard to, my lord. And my lord, our explanation is, my lord, that after there was an intervening vacation, my lord, that, my lord, we have said 17 May to 9 June. And thereafter approached learned senior counsel. My lord, Mr. Siddharth Sharma.
Have they applied for certified
My lord,
copy?
they have, but my lord, perhaps, my lord, perhaps, my lord, because, my lord, the records have been transferred, perhaps, my lord, there will be a difficulty, my lord, in getting the certified copy. That may be, my lord, the...
No. This
reason,
court's
because,
order, why this court's order is transfer?
because, my lord, it's all...
This court's order should be there.
All will be transferred.
Mr. Chakravarti, hey, this is an application for condonation.
Filing or opposition.
Filed. Affidavit in opposition filed on behalf of the respondent in connection with the application for condonation of delay, comma, BK with the record.
Stay application.
Oh,
Original
it is the
side.
original side. Affidavit of opposition filed to the stay application.
To the
only limitation.
To the issue of condonation of delay. No other issues was touched.
To the stay application filed by the respondent, comma, limited to the issue of condonation of delay, comma, be kept with the records. Paragraph, we have heard learned counsel for the parties. Stop. We are satisfied with the explanation. Now, although we are not fully satisfied with the explanation furnished for condonation, for the delay in presenting the appeal, comma, for the ends of justice, comma, we allow the application, we allow the prayer for condonation subject to the appellant paying costs assessed at rupees 5,000 to the state Calcutta legal service, basically state legal services authority within a week from date.
5,000 cost doesn't go with the stature of Mr. Banerjee.
50,000.
No, my lord, it goes. It goes. Kindly, my lord, restrict, my lord, the clause. আর ব্রিফ করবে না তোকে না তো এবার
না সত্যি 5,000টা বড্ড 10,000 করে দাও ঠিক আছে 587 দিন দিলে 10,000 হ্যাঁ ঠিক আছে
60 days.
Then when do you want the appeal to be heard?
Lord, 14, 15, my lord.
All papers are before us?
Yes, my lord. My lord, only short question is, my lord, whether, my lord, Suomoto can be... And, my lord, on the last occasion, my lord, assured, my lord, no further steps will be taken.
We have not appeared, he had appeared.
Paragraph. The short question involved in this appeal is whether the learned single judge could have Suomoto transferred the winding up petition.
And in this situation, because, my lord, it's there are arbitration orders which are relating to this company.
To the National Company Law Tribunal in the facts and circumstances of this case. Stop. We propose to hear out the appeal.
আর কিছু ফাইল করবো ওখানে নাকি সব আছে তো?
The stay petition has all relevant papers.
There's not, well, only the binding petition, there were the orders and nothing else.
All relevant papers are annexed to the stay petition, which may be treated as an informal paper book. Paragraph lists the matter under the heading for hearing when?
After 15th, sir, 15th.
After 15th, right?
Maybe after 15th, my lord.
15th of May?
After 15th of
Yes, on May 16.
No further, my lord, steps, my lord, by either parties.
No,
my lord.
no one. With
Either
this
party, my
order-
lord, no
But
further
with
steps
this-
by either of us, my lord, in this.
with
Mr.
this order-
Chakraborty says so.
My lord, kindly, my lord, at least, my lord, that assurance can be recorded because, my lord, my lord, there will be problem, my lord,
No
with the
further
NCL.
steps to be taken in the NCLT before.
Yes.
It is understood that since we propose to hear out the appeal, none of the parties herein shall take further steps
I'm grateful.
before the NCLT.
Grateful.
Grateful.
Until further order. Until further order.
Item number 32. 32, my lord, I am for the appellant, my lord.
Yes,
A similar matter, my lord, suo motu transfer of company petition to the.
that is the only point.
That is the only point, my lord. This appeal has been preferred by the employees, company staff, employees of the official liquidator, my lord. This is an impugned order is of 8 September 2022, my lord, and the appeal is of 2024. There is a delay of 690 days. My Section 5 application has not been filed.
Then,
And, I am praying for a leave to file my Section 5 application.
in the original side, there is no আলাদা করে তো করে না ওই সেম পিটিশনই করে বাট করেনি প্রেয়ারটা করেনি ফাইল
Yes, that is well.
learned advocate for the appellant
A week's time will suffice.
appellants করবে says that there is a delay of 690 days in presenting the appeal. Stop. He prays for some time so that the appellants can file an application for condonation of delay. Paragraph as requested by learned advocate, let this matter stand adjourned for 2 weeks. Stop. If in the meantime any application is filed, the same shall be listed with this appeal on the adjourned date. Adjourned date bracket দিয়ে দাও 15 May 15.
Deeply obliged, my lord. Deeply. And my lord, the affidavit of service is already on record on the last occasion. It has been.
Item number 33. Item 33, I appear for the appellant, your lordship, against an order dated, my appeal against an order dated 27th March 2025, where the learned.
Mohabir Properties inducted you.
Yes, yes.
Mohabir itself is a sub-lessee.
Sub-lessee. I've got.
No, Mohabir is a sub-lessee. He is a sub-sub.
I'm the
From
sub-lessee, your lordship.
88 suit, ultimately got decree after 17 years, then division bench, then Supreme Court. At last, how can they remain, my lord? I am not a.
Lordship, the only thing is, I'm.
Yes.
How can they continue, my lord? In my execution? They are.
Lordship,
So you are actually agreed by the cost, aren't you?
no, not just that, your lordship. It has been dismissed on merits. GF 14 was dismissed on merits. Lordship, I'm led by Mr. Bachawat. If your lordship would kindly keep it tomorrow, we shall argue it out. The only urgency is that today, before the learned executing court has passed an order directing the sheriff to take urgent steps.
Very good.
So your lordship would kindly keep this tomorrow. We shall argue it out, your lordship.
Tomorrow?
We shall argue it out.
What will you argue? We have read the matter. There's nothing to argue.
Grateful.
Pass on matter item number 29.
Grateful.
আমাকে কি হলো?
Lordship, we for item number 29. Lordship, I do not think both the sides senior counsels are present right now. So
You are for the
we for the respondents, Lordship.
respondent. 29 appellant ছিল? Not today করে রেখে দাও।
Hearing for the appellant, Lordship, the issue involved is, Lordship, in the liquidation process, security guards were appointed. Now, because the matter has been transferred to the NCLT, Lordship, the remuneration of the security guards, their salary and the payments that the official liquidator ought to have released, Lordship, that I'm not being able to realize. Now, I'm aggrieved by the order impugned by which the matter was transferred to the tribunal, Lordship. Similar judge, similar matter.
Jessup.
Yes, Lordship. Similar issue is being decided by your Lordships.
37.
S-
Transfer.
Correct. Correct.
the factors.
না না খুব ভালো সাজেশন, একদম ভালো সাজেশন করে দাও, ক্লাব ইট উইথ 37.
37 এর সঙ্গে ঠিক আছে।
But this matter has already been transferred to NCLT. And
Lordship, that
he is the security guard, my lord, appointed
You
by
know,
the
Mr.
official.
Chaudhary, we are hearing a similar point in Jessup. It will be tagged out with Jessup.
Lordship. ঠিক আছে, thank you. I'm great.
করে ওগুলো সবই যেসব তো ডাকবে, তুমি এখন করো না, ডাকো।
Partner 34.
ও হ্যাঁ, এইটাই। Yes, anybody would like to make any further submission? That is why.
By my leader, my lord, I'm looking.
I thought they concluded.
Certain judgments, copies of certain judgments were handed over to us. No submission was made on that.
Lordships, my lord, wanted us, my lord, to consider, my lord, a Supreme Court judgment, my lord, of Justice Sinha. My lord, I'll make my submissions on that. Yes, now, my lord. And my lord, I wanted, my lord, to, my lord, also draw your lordship's attention to one other judgment. Apropos, my lord, Justice Sinha's, my lord, decision. Because if your lordships, my lord, your lordships will kind.
No, not super take, I hope.
No. That's, my lord, there wasn't sanction. My lord, I'm not, my lord. Yes. Now, my lord, your lordship wanted us, my lord, to look at, my lord, 2008, 11 SCC.
That is one of the hurdles. The major hurdle, Mr. Mitru might have told you, is suit for land.
My lord, suit for land, I have a complete answer. My lord, for the simple reason that the entire case, my lord, has proceeded, my lord, on the basis, the plaint case, my lord, that a fraud has been committed within jurisdiction. That is covered, my lord, by our High Court judgment, which I shall cite straight away, my lord.
Justice Dotto?
Yes.
Single bench.
My lord, yes, it's single bench, my lord.
We have read that.
Because, my lord, I was faced with that very early on, my lord, in the profession. I thought, my lord, I had a classic case for suit for land. And, my lord, this was, my lord, the Kollan Shed, Milon Shed, my lord, brothers litigation which was going on. And this related to Puri properties. And, my lord, the fraud had been committed within jurisdiction. I'll show that, my lord. আমাকে তো দেওয়া নেই না। My lord, paragraph 11, my lord, your lordships will find.
Justice Dotto, we have read that. No, who cited these decisions? We are a little confused. Gopi Narayan Khanna, MacNeil and Megar, Porimol Mitro, Committee of Management of Pachapas Trust, Mohanlal Seal.
Mohanlal Seal, we would have cited.
But then altogether, these they have cited. They have handed up. Not cited, they have handed up.
Can we, my lord, we really?
No, then better. They were not formally cited, Mr. Bhattacharya.
Even though I cited.
That you did. We have told Mr. Mukherjee. We have read. But these we weren't cited. But you have handed over. So we are confused.
My lord, I'll tell your lordships what might have happened. my lord, your lordships will find, my lord, the learned single judge, my lord, has referred to these judgments. My lord, one is, my lord, there are two reasons, my lord, for citing, my lord, the Mohanlal Shield, my lord, judgment. My lord, number one, my lord, is, my lord, that, my lord, a sale of trust property should be, my lord, with adequate publicity.
Mr. Mukherjee, we'll rise in 10 minutes. Now, Mr. Mitro, have you been given this list? No.
No, I did not know it.
If you wish to make any submission, kindly supply the particulars. Come back and you can carry on now. We still have 14 minutes.
We are hoping to, my lord, have another innings also, my lord, in the next matter where my learned friends on the other side. My lord, that's just a,
Oh, acha. Very well.
my lord, maximize returns.
Yes.
My lord, as per IBC.
Very well. Then when?
My lord, tomorrow, Monday, any time. My lord.
Tomorrow is a difficult.
সেগুলো তো রেফার করেনি এখানে কিছু বলেনি
Tomorrow? Just these cases you consider? That's all.
My lord, may I put it this way? My lord, your lordships would have seen, my lord, apropos suit for land. First, my lord, is, my lord, the main hurdle. My lord, our first submission, my lord, would be, my lord, on the basis of, my lord, Justice Dutt's, my lord, decision, my lord, and, my lord, the averments made in the plaint, my lord, there is no bar. Secondly, my lord, if we were to give up prayer C, and which is possible, my lord, in law, there's a division bench judgment of our court, my lord, on the basis of the other reliefs, which are all in personam, my lord, we are entitled to, my lord, this interim order as well. These are the two, my lord, aspects, my lord, which, my lord, I wish to, my lord, my lord.
You have already indicated.
So, my lord, this is, my lord, the way I look at it.
So tomorrow we'll only list it for Mr. Mitro to deal with these cases. Otherwise, we have heard arguments at length.
Yes, yes, my lord, I wasn't, my lord, I'm sorry I couldn't assist my learned friend, my lord. I was, my lord, caught up, my lord, in an.
না না পাঁচটা কেস নিয়ে কতক্ষণ we'll mark it and we'll keep it at 12 p.m. to 12 noon. You're not available?
No, no, I'm my learned seniors. No, no, I am there.
12 o'clock, you please wind up by 12:30 because we have a special bench at 12:30. Lekho? Mr. Mukherjee, learned senior advocate representing the appellant, makes his submission.
I'm for them.
Oh, sorry. For the plaintiffs.
Respondent number 1.
For the plaintiffs. Respondent number 1 only.
The plaintiffs.
For the
Respondent
plaintiffs.
number 1 and plaintiffs.
For the
One and-
plaintiffs makes his submission. Paragraph lists this matter once again. Kalki date diye dao, marked 12.
Mr. mentioned Surojit Nath Mitro, not Mr. Mitro.
Huh?
Your lordship has just now said Mr. Mitro.
Well, it should be Surojit Nath Mitro there too.
Oh, Mr. Surojit Nath Mitra.
I do not want to make submissions on their behalf.
ভালো হয়
হ্যাঁ, বলতে যাচ্ছি।
বললে ভালো হয় আরে কেন বললে
কোনটা বলো তো?
In the High Court, that's all I
বলে দাও, বলে দাও। হ্যাঁ, ঠিকই আছে। Is this matter once again? We have said Mr. Mukherjee.
Yes.
There is only one Mukherjee.
Is that Kalki date marked 12 noon for Mr. Surojit Nath Mitro to make submission. Please also consider both of you one case.
I am also appearing for one of the defendant. If I need to supplement something,
Finish off by 12:30, that's all.
Mr. Court's name will be recorded only that he appeared. For good reasons.
Can I?
Yes.
Can I, my lord,
This also 2005 volume 7 SCC 791.
Both of you, both sides.
2005 7
এইটা নাও, এই লিস্টটা একটা ওনাকে দাও।
This is the proposed Justice Dutt's judgment.
দিয়েছিলেন।
Proposed judgment of Justice Dutt
Yes.
says that
না না
for this can be considered.
Apropos that, we have given you Supreme Court to consider.
আমরা দিয়েছি
ঠিক আছে
ঠিক আছে, ডাকো, নেক্সট ডাকো।
Now this bench
number 35
will be very hardworking bench.
My brother does all the work.
We have to be careful.
Item 35, I am for the appellant. I'm part-heard before my lord. Today it won't fail.
Oh,
That no
arbitration.
1940 Act. No
Pre-going,
prisons,
pre-going.
Pre-going. It's a pre-going argument also. My lord will only not keep it tomorrow. My lord, if it can be on Monday.
Monday.
May I, my lord, seek an indulgence?
Tomorrow.
Oh, tomorrow, your lordship has a 12:30 bench. Lord, if it's Monday, my lord will kindly give a time.
It's
Sorry.
the first matter, part-heard.
First matter.
This is top, but I
Sir, we waited the whole day in vain. Though. No doubt about that.
because I noticed today there was a matter fixed, which is why, my lord, I was making this prayer that
Very well. Monday, 4:30 p.m.
Item number 36.
Should I appear in this?
Regarding my lord, the eviction suit has been filed, and therefore a terms of settlement has been filed, but specific term was given that after 10 years, the possession will be handed over. And my lord,
The written notes have already been filed by both the sides. Lordship, the short point.
একবার মেমোটা দাও। বোধহয় আরো আগেকার। 1865. First CPC কবেকার? 1899 এর একটা CPC ছিল, তাই না? ওইটাই কি ফার্স্ট, তার আগেও CPC ছিল? জানি না। এটাই অপূর্ব।
in this matter, Mr. Shatarup Banerjee is leading me, my lord, and he is stuck in court number 6, my lord.
What do you want?
Maybe adjournment, maybe matter may be taken up tomorrow.
Your execution application has been dismissed.
Yes, my lord. Dismissed on the pretext that
চলো Monday. চট করে ডাকো।
37 to 39.
37. Lordship, I am for the official liquidator.
Cholish.
এই শোনো। কবে করবে এটা?
2 minutes বললে মিটারটা উঠবে, তারপরে
রিপোর্ট তুমি কার কি রিপোর্ট আছে? This is that matter, my lord.
My lord, about transfer, my lord, to my lord, the adjudicating authority.
Mr. Ratnanku Banerjee was appearing.
I'm leading him, no, my lord. I should also say he could be leading.
Tell us, we recorded the arguments advanced on the last date in our order.
Yes. I'm going to expound that particular
Are we to
submission.
yes, amplify on that.
Now, two issues arose, my lord. Perhaps my learned friend was not there. First is whether suo motu transfer can be made. Number one. And number two is what is the implication of the proviso on the main section, provision number 5. And in addition, my lord, I shall make my submissions that perhaps in a situation like this,
You are for Edelweiss.
Yes, ma'am.
yes. I first of all question my learned friend Lucas. Remember,
Standing outside the winding up.
standing outside the winding up. Therefore, he is not a party who is entitled to make the application. That is the first point. Second point, my lord, whether it is a if my lord he is outside the party, whether he can draw your lordship's attention to the facts and say that even though I am outside the party, but it is so motu power of the court, therefore court can take it over. That's the second point. Third point, my lord, I shall submit to your lordship that in so far as the facts of the present case is concerned, my lord, there cannot be there is sufficient reason as to why it should not be transferred. It is this irreversible position, whether that is there or not.
Nobin Chandra, steel and action.
Action Ishpat, Naveen Chandra, there are other judgments
Several
also.
judgments, ma'am.
Several judgments, what it means by irreversible situation. I'll have to explain it to your lordship that. These are the 3 points I'm going to address your lordship on.
Before we end today, it was heard today. Let us understand. We'll record an order.
Yes,
We'll
this is the
record an
first
order.
condition my learned friend has imposed upon me.
Is we ensured that it is called on. That is why. I remember when I was in practice, court number 8. I was sitting, Mr. Mitro came in, so I offered him the chair, he sat down. After a few minutes, his cell phone started ringing in his pocket.
Dismiss again.
I am for the respondent in this matter.
A connected
Third.
matter was
The
called
only
in the
thing is
court.
that, my lord, if your lordship is restoring that matter, my lord, kindly make one observation. It is a 2017 appeal.
But I
They
will-
have
I will
taken time
conclude in
before
one-
the execution court
I
saying that the
undertake-
appeal is
But
listed.
I undertake to conclude in one day. Your lordship will kindly keep it next week. I'll conclude on that.
13-14 টা করো না তাহলে।
And my lord, only one observation: the execution court shall not be precluded to proceed, my lord, because
One.
there are
Well,
checkered
I-
history, my lord. They are disposing of their property in violation of
তাহলে
injunction.
এটাতে একটা অন্যরকম অর্ডার রেকর্ড করো।
Injunction violate.
13 and 14 একই অর্ডার দুটোতে রেকর্ড করবে। Accommodation is sought for on behalf of the appellant. Stop. Let this matter be listed again on Monday date thou. Paragraph, we clarify that pendencies of this appeal shall not be construed as stay of the execution proceedings.
Lord, item 35 instead of Monday, my lord, kindly keeps it on Wednesday, my lord. I'll inform Mr. Ghosh.
35?
Kept on Monday, my lord, Wednesday, kindly.
35 ধ্রুব যেটা, হ্যাঁ।
My lord,
তাহলে Wednesday করো।
I'm
before your lordship rises, my lord, very sorry. My
Huh.
lord, today's 3:30 fixed matter, my lord. maybe after 6th of May, my lord. Today it could not be taken up because of 3:30.
Why was it fixed at 3:30?
Because, my lord, Mr. Mitra has started making submissions in respect of the Section 37 appeal, my lord. My learned friend is on the other side.
Mr. Mitro?
My lord, in respect where my Section 9 has been dismissed, my lord, it pertains
Mr. Which Mitro?
Opposite Mitra. So, my lord had kept it today, my lord, for further submissions. He had already started making his submissions.
No outstation council is involved.
No outstation council is involved, my lord.
7th May রাখো এখন তো দেখা যাবে।
Grateful,
এটা
my lord.
3:30 আছে।
Grateful, my lord. Deeply.